You follow laws every day. You assume they're reasonable. You assume they make sense. You are wrong on both counts, and it's about to get embarrassing. 1. Somewhere in the legislative history of Atlanta, Georgia, a lawmaker sat down, surveyed the horizon of pressing civic problems, and decided the city needed an explicit ordinance prohibiting the tying of giraffes to telephone poles. This law is real. It is currently on the books. It has survived decades of municipal housekeeping without anyone feeling the urgency to remove it. Legal scholars have a name for statutes like this: zombie laws, regulations that were never repealed and remain technically enforceable despite being completely irrelevant to any recognizable feature of modern life. Georgia has never had a wild giraffe population. The origin of the law cannot be traced to a single documented incident involving a giraffe, a pole, or any combination of the two. The reason these laws persist is purely economic. The legislative process required to formally remove them costs more in staff time and floor hours than simply leaving them alone to haunt the municipal code forever. So the ordinance stays. The giraffe prohibition endures. Somewhere in Atlanta's legal infrastructure, the giraffe problem remains technically solved, which means it also remains technically your problem if you show up with one. 2. In Gainesville, Georgia, eating fried chicken with a fork is technically illegal, not metaphorically, not as a colorful regional expression. The law is part of the actual municipal code, passed in 1961 as a publicity campaign to promote Gainesville's identity as the self-declared poultry capital of the world. The only legally sanctioned method of consuming fried chicken within city limits is with your bare hands. In 2009, a woman was mock arrested and subjected to a ceremonial trial under the ordinance as a public relations event, which proves two things simultaneously. The law still exists, and the city is fully aware of how it reads to the outside world. The ordinance has never been formally repealed, meaning it occupies that particular category of American law where the joke is the legislation, and the legislation is the joke, and neither side appears motivated to end the arrangement. You are not required to visit Gainesville, but if you do, and you produce a fork within range of a chicken, you are operating in a legal gray zone that a real judge once presided over in a theatrical context. Put the fork down. This is the law. 3. You probably believe that Sunday has been legally unrestricted in America for roughly a century. You are off by several decades in most states and by the entire concept in others. Blue laws, regulations restricting commerce on Sundays, originated from Puritan colonial legislation designed to enforce Sabbath observance as a civic and religious duty, and they did not quietly retire when the colonies became a country. As of 2024, over 500 dry counties and municipalities still prohibit alcohol sales entirely, concentrated heavily in the South and Midwest. Texas blue laws historically banned the sale of specific items on Sundays, and the list had to be legislated item by item, which means someone in the Texas legislature once held a floor vote on whether pots and pans were sufficiently secular for weekend commerce. Bergen County, New Jersey maintained strict Sunday shopping restrictions until 2013 in one of the most densely populated counties in the entire country. Several states still prevent car dealerships from operating on Sundays. The government once decided God had opinions about cookware sales schedules, codified those opinions into law, and in several jurisdictions, those opinions are still technically governing your weekend purchasing behavior. 4. Virginia has a law prohibiting hunting most animals on Sundays. The exception, and there is always an exception in American law, is raccoons, which may be legally hunted until 2 in the morning. Not midnight, not sunrise. 2 in the morning specifically. The Sunday hunting ban itself dates to colonial-era blue laws and remained largely intact for over 300 years, which is an impressive run for any legislation not involving raccoons. Virginia only began lifting the ban for other animals starting in 2017, after decades of legislative debate about whether the Sabbath had specific feelings about deer. The raccoon carve-out survived because raccoon hunting is traditionally conducted at night with dogs, and the hunting lobby successfully protected this specific exception through whatever negotiation produced it. The 2 in the morning cutoff has no documented scientific basis related to raccoon behavior, conservation biology, or any field of inquiry that has ever considered raccoons academically. It appears to be an arbitrary hour that satisfied the parties involved in a negotiation about nocturnal mammal pursuit. Somewhere in Richmond, legislators once sat across a table and seriously debated what time raccoons deserve legal protection from Virginians with dogs. The answer they reached was 2. 5. You believe your cash is yours. You carry it. You earned it, and its physical presence in your pocket represents a kind of financial sovereignty that no institution can touch without due process. Under civil asset forfeiture laws operating in most American states, law enforcement can legally seize your cash without charging you with a crime, and the legal burden to recover it falls almost entirely on you. The Institute for Justice has documented thousands of annual cases where individuals had cash taken at traffic stops, airports, and checkpoints without any criminal charge ever filed against them. The DEA alone seized over $3 billion from people never charged with drug offenses between 2001 and 2014, according to a Washington Post investigation of that scope and duration. Several states, including New Mexico and North Carolina, have passed reforms, but the Federal Equitable Sharing Program allows local departments to partner with federal agencies and bypass state-level restrictions. Your cash can be arrested before you are, subjected to a separate legal proceeding, and effectively convicted without anyone proving you personally did anything wrong. The money gets the trial. You get a receipt. This is not a metaphor. This is the active legal framework governing American currency in your pocket right now. 6. The word jaywalking sounds like it has always existed, like a neutral description of a traffic behavior. It was not always a word. It was invented. The automobile industry manufactured it in the 1920s through a coordinated lobbying and press campaign specifically designed to shift blame for pedestrian deaths away from vehicles and onto the people being struck by them. Before this campaign, streets were understood as shared public space belonging equally to pedestrians, horses, streetcars, and cars. The National Automobile Chamber of Commerce funded efforts to redefine crossing outside a crosswalk as reckless and embarrassing, borrowing the term jay from slang for an unsophisticated rural person unfamiliar with city customs. The implication was clear. Only rubes walk where they want. Legislatures adopted this framing. California decriminalized jaywalking in 2023 under the Freedom to Walk Act, and multiple cities moved toward decriminalization after data showed citations were disproportionately issued to Black and Latino pedestrians. The car industry decided in 1920 that the street belonged to cars, invented a derogatory term for people who disagreed, convinced elected officials to criminalize walking, and a century later, you are technically a criminal in several jurisdictions for crossing an empty street on foot. Progress is slow. 7. If it falls from the sky onto your land, it is obviously yours. Rain lands on your roof. You want to collect it. This is the most basic possible interaction between a property owner and weather, and in Colorado it was illegal for most of the 20th century. The prohibition was not arbitrary cruelty. It was a product of prior appropriation, water rights doctrine, a legal framework governing Western states that treats water as a property right tied to specific uses and users. And under this framework, the rain falling on your property was legally considered downstream water, already belonging to other rights holders before it touched the ground. Colorado only legalized limited residential rainwater collection in 2016, and the permission is not unlimited. You are allowed 2 55-gallon barrels maximum. Utah similarly restricted rainwater collection until 2010, after which residents were permitted up to 2,500 gallons, but only after registering with the state government. The prior appropriation doctrine remains active across 17 Western states. The sky has a legal ownership structure. The rain falling toward your property has already been allocated before it arrives. Your roof is real. Your legal claim to what lands on it is considerably more complicated than gravity suggests. 8. The United States has no comprehensive federal law governing private ownership of exotic animals, which is why an estimated 10,000 tigers currently live in private American hands, a number exceeding the total wild tiger population on Earth. The regulatory landscape is not a system. It is 50 separate systems assembled by 50 legislatures that never coordinated. In some states, you could legally own a 500-pound apex predator with minimal paperwork for decades. The Big Cat Public Safety Act passed federally in 2022 and only began phasing out private big cat ownership gradually. Meanwhile, in Georgia, Hawaii, California, Pennsylvania, and all 5 New York City boroughs, owning a hedgehog is illegal. A hedgehog. The regulatory framework that tolerated private tigers for decades draws a firm line at small spiny mammals. Capybaras, the world's largest rodent, are legal in Texas and Pennsylvania and illegal in California and Georgia, meaning the same animal purchased legally in one state becomes contraband if you relocate. The logic governing which animals you may legally possess in America was written by people who were not talking to each other, reaching conclusions that are not compatible with each other, enforced by agencies that are not coordinating with each other. The result is the current situation, which is 10,000 tigers. 9. The legality of sleeping in your own car in a parking space in America has been argued before the Supreme Court of the United States. This is not an exaggeration. The Ninth Circuit Court of Appeals ruled in Martin v. City of Boise in 2018 that cities cannot criminally punish people for sleeping outdoors when no shelter alternative exists, a ruling affecting enforcement across Western states. Cities responded by passing anti-camping ordinances specifically targeting vehicles, some requiring cars to be moved every 72 hours regardless of circumstance. Several states simultaneously created safe parking programs, officially sanctioned lots where people may legally sleep in vehicles overnight, establishing a formal legal status for car sleeping that exists alongside ordinances criminalizing car sleeping depending on which parking lot you chose. The Supreme Court's 2024 ruling in Grants Pass v. Johnson narrowed the earlier Boise decision, giving municipalities more latitude to enforce anti-camping restrictions regardless of shelter availability. Whether parking your own car in a public space and sleeping in it is a constitutional right, a municipal violation, or a formally permitted activity in a designated lot depends entirely on which city you are in, which week it is, and which court last ruled on the question before you arrived. 10. There is no universal federal law requiring you to show your identification to a police officer who asks for it. This is not a loophole. It is the actual legal structure of stop and identify authority in America, and it depends almost entirely on which state you happen to be standing in when the request occurs. As of 2024, only 24 states have stop and identify statutes legally requiring you to provide your name to an officer who has reasonable suspicion you are involved in criminal activity. In the remaining states, including California, a state with some of the most extensive police-citizen interaction in the country, you are generally not required to provide identification during a consensual encounter. The Supreme Court addressed this in Hebel v. 6th Judicial District Court of Nevada in 2004, upholding stop and identify laws but explicitly declining to create a universal national standard. The requirement to produce identification during a traffic stop is separate and more consistently applied to drivers, but passengers in most states are not legally required to show identification at all. Whether you must hand over your identification to a law enforcement officer depends on which side of a state line you are standing on. No sign marks the boundary. The legal requirement changes anyway. 11. Your house is your property. What you do to its exterior, The color you choose, the way you present it to your neighbors and to the sky, is a matter of personal sovereignty over real estate you legally own. In the understanding of approximately 74 million Americans currently living under HOA governance, this is not how it works. Homeowners associations legally restrict exterior paint colors in most of their governing documents, commonly limiting acceptable choices to a palette of 2 to 5 approved shades selected by a committee. You did not elect to govern decisions you did not anticipate surrendering. Historic preservation districts, which exist in thousands of American cities, require paint color approval from a municipal board before any change to an exterior surface is made. Miami Beach's architectural district requires homeowners to submit physical color samples for board review in a process that can take months and require revision before approval is granted. HOA fines for unapproved exterior colors have reached tens of thousands of dollars in documented cases, including a Virginia homeowner who accumulated over $8,000 in fines for painting a door an unapproved shade of red. You bought the land. You own the walls. A committee owns the palette. This is called property rights in America. 12. You assumed that turning 21 resolved your relationship with American alcohol law. It did not. It resolved the age component. What remains is a regulatory landscape so layered, so contradictory, and so geographically inconsistent that it requires a specialist to navigate without accidentally committing a violation. As of 2024, over 500 dry counties or municipalities in the United States prohibit alcohol sales entirely. Kentucky, which produces a significant portion of the world's bourbon whiskey, contains more dry counties than wet ones. A state that built an internationally recognized industry around distilled spirits has a majority of its land area where those spirits cannot be legally sold. In Utah, restaurants were required until 2019 to mix cocktails behind a physical barrier called the Zion Curtain, a partition preventing customers from watching the mixing process, theoretically protecting children from the sight of ice entering a glass. Some states still require you to join a private membership club to consume alcohol at certain establishments, a legal fiction designed to circumvent public sale restrictions that continues to operate in active jurisdictions today. The law that governs when, where, how, and by whom alcohol can be sold in America is not a system. It is 50 separate experiments running simultaneously with incompatible results. 13. Voting is in the Constitution. It is the foundational act of American democratic participation. Surely the mechanics of exercising this foundational act are straightforward, consistent, and designed to maximize the ease of participation. As of 2024, 35 states have voter identification laws, and the type of identification required varies so dramatically between them that a student ID accepted in one state is specifically prohibited in another. North Dakota has no voter registration requirement of any kind. Oregon, Washington, and Colorado have automatic registration. Most other states require active registration with deadlines ranging from 7 to 30 days before an election, meaning the same preparation timeline that qualifies you to vote in one state disqualifies you in another. Felon disenfranchisement laws range from Maine and Vermont, which allow imprisoned felons to vote, to several southern states where a felony conviction requires individual clemency to restore voting rights, potentially permanently. The Help America Vote Act of 2002 attempted national standardization after the 2000 election and left enormous discretion to individual states. The most fundamental act of American democracy has 50 different rule books. None of them are required to be compatible with each other. None of them are posted anywhere you will see before you need them. 14. Your home, your speakers, your music, your yard on a Saturday afternoon. The assumption that this sequence of possessions and circumstances gives you legal authority over what sounds emerge from your property is a reasonable assumption that is wrong in ways that vary specifically by municipality. New York City's noise code makes residential noise actionable at 45 decibels, measured inside an affected neighbor's apartment between 10 in the evening and 7 in the morning. 45 decibels is approximately the volume of a quiet conversation. Portland, Oregon has enacted ordinances where amplified music outdoors on private residential property requires a permit for gatherings above a certain guest count. Los Angeles prohibits persistent noise that disturbs neighbors, but defines persistent with enough ambiguity that enforcement is essentially discretionary, producing situations where two identical parties on the same block receive different legal outcomes based on which officer responded to which complaint. Several HOA agreements prohibit outdoor music after 9 in the evening or before 9 in the morning every day of the week, making a Sunday morning gathering legally actionable under civil contract law before you have finished your first cup of coffee. New York's legal threshold for your noise is quieter than most running refrigerators. Your party was technically a violation at the planning stage. This is the regulatory environment of your backyard. 15. You are standing in public. Something is happening in public. You point a camera at the public event. This is not a complicated legal scenario, except that whether your recording is legal depends on which state you are in, whether any spoken words were captured, whether the people speaking consented to capture, and whether you are recording a police officer in a jurisdiction where wiretapping law has been applied to that specific activity. Two-party or all-party consent states, including California, Florida, Illinois, Maryland, Massachusetts, Nevada, Oregon, and Washington, require all parties to a conversation to consent before it can be recorded. In these states, recording a police officer's conversation during a traffic stop has been prosecuted under wiretapping statutes, even when the officer was performing a public function in a public location. Federal courts have broadly affirmed a First Amendment right to record police in public, but the Supreme Court has never directly ruled on it, making the protection real in some circuits and unresolved in others. Several states have passed agricultural facility laws, making it illegal to record from public roads adjacent to private farms. The Federal Aviation Administration regulates drone photography over your own backyard. Your constitutional right to film public events exists in theory approximately 3 to 5 years before it exists in practice. 16. The lemonade stand is a mythology. It is the story America tells about itself. The young entrepreneur, the sidewalk, the handwritten sign, the fundamental simplicity of commerce conducted between willing parties on a summer afternoon. In 2011, county officials in Midway, Georgia, shut down a lemonade stand operated by 3 girls between the ages of 10 and 14. The required permits included a business license, a food handler's permit, and a temporary food establishment permit costing $50 per day. In 2015, police in Overton, Texas, shut down 2 girls for lacking a peddler's permit. That case went viral. The Texas legislature responded by passing a law specifically exempting children's lemonade stands from permitting requirements. As of 2023, at least 14 states have passed laws explicitly protecting children's lemonade stands from enforcement action. The fact that 14 state legislatures had to pass specific legislation to protect a child's right to sell a beverage from a folding table means 36 states technically retain regulatory frameworks under which that same activity remains potentially actionable. America loves the lemonade stand mythology so completely that it has been forced to legally defend the mythology from the rest of its own regulatory apparatus, one state at a time, at the speed of legislative sessions. 17. The First Amendment is national. Police officers are public officials performing public duties in public spaces. Recording them is a settled constitutional right. This is what you believe, and it is approximately accurate in the way that a weather forecast is approximately accurate. Correct about the general direction. Imprecise about when it actually arrives at your location. Between 2010 and 2020, the ACLU documented hundreds of cases where individuals were arrested while recording police, prosecuted under disorderly conduct, obstruction, or wiretapping statutes in jurisdictions where circuit courts had already ruled the activity protected. The Supreme Court has never directly held that recording police is a First Amendment right. The protection comes from circuit court decisions, binding only in those circuits, subject to future challenge, and representing a legal reality that exists in some federal jurisdictions and remains unresolved in others. Illinois prosecuted individuals under its eavesdropping statute for recording police officers until the Seventh Circuit struck the law down in 2012, but the prosecutions happened before the protection arrived. Police departments have confiscated phones of recording bystanders in documented cases. Courts have consistently called this unconstitutional. The confiscations continue to occur. Your constitutional right to record operates at appellate speed. The handcuffs operate considerably faster. 18. Miranda warnings are not required at the moment of arrest, and the gap between what television taught you and what the law actually says is wide enough to drive a serious criminal consequence through. Miranda v. Arizona, decided in 1966, established that warnings are required only when a suspect is both in custody and being interrogated, not at the moment of handcuffing, not during booking, not during processing. Police can arrest you, fingerprint you, photograph you, and hold you without reading a single word of those rights as long as they do not question you. If they fail to Mirandize before interrogation, the remedy is suppression of statements made during that specific interrogation, not dismissal of the case. Physical evidence discovered as a result of an un-Mirandized statement may still be admissible under the inevitable discovery doctrine. The Supreme Court ruled in Vega v. Teco in 2022 that failing to provide Miranda warnings does not by itself violate the Constitution, meaning you cannot sue an officer for damages simply because they skipped the speech. Routine booking questions, including your name, address, and date of birth, are explicitly exempt under the booking exception. The most famous legal speech in American pop culture is required in fewer situations than any crime drama has ever implied. 19. Your first-class letter requires a warrant to open, which creates the impression that the postal system is a sanctuary of private communication between sender and recipient. The exterior of that letter is a different matter entirely. The mail cover program, operated by the United States Postal Inspection Service, allows law enforcement to record all information appearing on the outside of any mail piece, including name, return address, postmarks, and routing information, without obtaining a warrant. This program processed over 50,000 requests annually, according to Inspector General reports, and it has operated for decades without most Americans being aware it exists. The constitutional protection for mail content created a tiered privacy system where what is inside the envelope is protected, and everything written on the outside of it is an open record available to investigators. Packages sent via lower priority mail classes have weaker protections than first-class items, meaning your method of shipping determines your constitutional protection level. Drug-sniffing dogs can examine the exterior of packages at postal facilities without a warrant under United States v. Place from 1983. Your sealed letter is private. The envelope carrying it has been a legally documented information source for law enforcement the entire time you assumed it was just packaging. 20. Jury nullification is not illegal. Courts will not tell you it exists. Judges will instruct you to follow the law as given. Attorneys who mention it risk sanctions. And yet, the power itself, a jury's ability to acquit a defendant despite clear evidence of guilt because the jurors disagree with the law itself, is constitutionally embedded and cannot be reversed. The Supreme Court has never held nullification to be illegal, and the double jeopardy clause makes an acquittal final regardless of the reason behind it. Courts refuse to instruct juries about this power, and in several circuits, judges have removed jurors reported to be considering nullification, a practice legal scholars continue to debate as inconsistent with the Sixth Amendment. The history of nullification cuts in both directions. Northern juries used it to acquit abolitionists who aided escaped enslaved people under the Fugitive Slave Act, and Southern juries used it to acquit individuals who committed racially motivated violence throughout the 20th century. Distributing pamphlets about jury nullification outside courthouses has been prosecuted as jury tampering in multiple cases, though many were dropped. Jurors have the power to acquit anyone for any reason. Courts know this. The Constitution guarantees the outcome is irreversible. Explaining this to a juror before they use it remains legally contested. 21. The red light camera ticket that arrives in your mail feels like objective, machine-generated evidence of a violation you committed, impersonal and airtight. The camera saw you. The camera recorded you. The camera is not capable of corruption or bias. The camera, in several American cities, was operated by a private company that was actively bribing the municipal officials who awarded it the contract. Redflex, one of the largest private camera system operators in the United States, had its chief executive resign in 2013 after a bribery investigation in Chicago revealed payments to city officials to secure and maintain contracts worth millions. Multiple cities, including Houston and Los Angeles, shut down their red light camera programs entirely after studies found they increased rear-end collisions at camera intersections by up to 40%, producing net safety results that did not justify continuing the programs. The Sixth Amendment's Confrontation Clause creates ongoing constitutional tension with camera-based citations because the accuser is a machine, a fact courts have resolved differently across jurisdictions. Some programs issue tickets to the registered vehicle owner regardless of who was driving, reversing the normal requirement that the government prove the named defendant committed the violation. The camera was watching. The camera also had a financial arrangement to protect. 22. One phone call is the universal rule of American arrest. You have absorbed this from decades of television, film, and casual cultural repetition. It is not in the Constitution. There is no federal constitutional provision guaranteeing a phone call after arrest. The Sixth Amendment's right to counsel is the constitutional foundation, but it does not specify a phone call as the delivery mechanism or set a time limit for its exercise. State law fills this gap differently in every jurisdiction. California law guarantees 3 completed phone calls within 3 hours of booking, not 1, and specifically includes the right to call an attorney, a bail agent, and a family member. Some states guarantee a call within a reasonable time, a phrase courts have interpreted loosely enough to produce documented cases of individuals held for over 24 hours before being permitted to contact anyone. During mass arrest situations, including large-scale protest-related enforcement actions, civil liberties organizations have documented systematic delays in phone access across multiple cities during the 2020 events. The most famous right in fictional American law enforcement is absent from the Constitution, ranges from 1 call to 3 calls depending on your state, and is suspended in practice during the exact circumstances when you are most likely to need it. 23. The census counts people every 10 years. You fill out the form. The government tallies the results, and the democratic machinery of apportionment and representation operates accordingly. This is the version of the census that exists in civics education. The American Community Survey, a separate instrument administered by the Census Bureau to approximately 3.5 million households every year, asks about your household income, health insurance status, disability, mortgage costs, commute time, and whether your home has functional plumbing. Responses are legally required under Title 13 of the United States Code, backed by fines for refusal. In 2000, the Census Bureau publicly acknowledged that during World War II, it provided the War Department with the names and addresses of Japanese Americans by neighborhood, data used to facilitate the forced relocation of approximately 120,000 people. The Trump administration's attempt to add a citizenship question to the 2020 census was blocked by the Supreme Court after internal documents revealed the stated rationale was pretextual, designed to depress response rates in immigrant communities. Census data determines congressional apportionment and the distribution of approximately $1.5 trillion in federal funding annually. The form counts people. It also does considerably more than that, and it always has. 24. The United States Flag Code is a federal statute specifying how the American flag must be treated. It prohibits using the flag as wearing apparel, bedding, or drapery. This provision is violated by virtually every piece of flag-themed merchandise sold at any sporting event, political rally, beach boardwalk, or national holiday celebration in the country. The Flag Code carries no penalties and has no enforcement mechanism, which is legally relevant because the Supreme Court ruled in Texas versus Johnson in 1989 that flag desecration is constitutionally protected speech. Congress passed the Flag Protection Act of 1989 in direct response, and the court struck that down as well in United States versus Eichmann in 1990, reaffirming the protection. Veterans organizations have lobbied for a constitutional amendment allowing flag desecration laws in every Congress since 1995. The amendment passed the House multiple times and failed in the Senate by a single vote in 2006. The result is a federal statute governing flag treatment in considerable detail, backed by no penalties, unenforceable as criminal law, and violated daily by the merchandise industry at every patriotic occasion. The flag has a detailed legal code. The code has no teeth. The flag print swimwear is both a technical violation and a bestseller. 25. The Pledge of Allegiance has been compulsory in American public schools in the cultural imagination for so long that the legal reality has almost no connection to the public perception of it. West Virginia State Board of Education versus Barnett decided in 1943 held that compelling students to salute the flag and recite the pledge violates the First and 14th Amendments. This ruling is over 80 years old. It was decided during World War II. Multiple states have passed mandatory pledge legislation since the ruling that was subsequently challenged and invalidated, and several states continued carrying technically unenforceable mandatory statutes on their books for decades afterward. The phrase "under God" was not part of the original 1892 pledge written by Francis Bellamy. It was added in 1954 during the Eisenhower administration as an explicit Cold War response to what was characterized as godless communism. The original hand gesture used while reciting the pledge before 1942 was an outstretched arm pointed toward the flag, a position Congress changed to the hand over heart after it became uncomfortably associated with a specific European salute, gaining international attention at the time. The mandatory pledge was ruled unconstitutional before your grandparents completed elementary school. The tradition continued largely undisturbed by this information. 26. Corporate law requires executives to maximize shareholder profit. Fiduciary duty to shareholders is a legal mandate. The board must prioritize returns above all other considerations because the law says so. None of that is true in the way it is commonly stated. No American law explicitly requires corporations to maximize shareholder profit. The concept derives primarily from Milton Friedman's 1970 New York Times Magazine essay, arguing that profit maximization is a corporation's sole social responsibility. This was an economic philosophy piece, not a legal analysis. The business judgment rule, the actual legal standard governing corporate director decisions in most states, protects directors from liability when they make good faith business decisions considering a range of factors, not exclusively shareholder returns. Delaware, which governs incorporation for over 60% of Fortune 500 companies, imposes no shareholder primacy mandate under normal operating conditions. 35 states have enacted constituency statutes explicitly allowing boards to consider employees, customers, communities, and other stakeholders when making decisions, directly contradicting any claim that shareholder primacy is a legal requirement. The legal requirement to maximize shareholder profit, used for 50 years to justify layoffs, environmental shortcuts, and pension raids, was never in the statutes. It was in a magazine. It became doctrine through repetition. The repetition was mistaken for legislation. 27. Double jeopardy is absolute. If you are acquitted, the case is over. New evidence cannot reopen it. No prosecutor can take another run at the same charges. A 1999 film built an entire thriller premise on this guarantee, and the guarantee, while real, has enough structural exceptions to power a law school examination. The dual sovereignty doctrine holds that state and federal governments are separate sovereigns, each with independent authority to prosecute the same conduct under their own laws. A person acquitted in state court for a racially motivated attack can be and has been prosecuted federally under civil rights statutes. The Rodney King case is the most prominent example in modern American legal history. Double jeopardy attaches at different procedural moments: in a jury trial when the jury is sworn in a bench trial when the first witness takes an oath. Before that point, charges can be refiled without constitutional bar. Hung juries, where jurors cannot reach a verdict, do not constitute acquittals and trigger no double jeopardy protection, meaning the government may retry with an entirely new jury. The Blockberger test allows prosecution for multiple separate offenses arising from a single act if each offense requires proof of an element the other does not. Double jeopardy is a real protection. Its edges are heavily populated. 28. Federal whistleblower protection is a cornerstone of American government accountability. If you witness fraud and report it, the law shields you from retaliation. This is what the framework is described as providing, and it describes an incomplete picture with gaps large enough to accommodate major documented cases of retaliation proceeding legally through them. There is no single comprehensive federal whistleblower protection law. Protection depends entirely on which sector you work in and which specific statute applies to your disclosure. The Whistleblower Protection Act covers federal employees. The False Claims Act covers private employees reporting contractor fraud. Sarbanes-Oxley covers securities fraud. An employee in the wrong sector invoking the wrong statute may find themselves legally unprotected. Edward Snowden was charged under the Espionage Act, which carries no whistleblower defense, meaning his stated intent to expose unconstitutional surveillance was legally irrelevant to his criminal liability. Reality Winner received 5 years and 3 months for leaking a classified document about Russian election interference, the longest sentence imposed on a federal leak defendant at that time. The Intelligence Community Whistleblower Protection Act requires internal reporting through the agencies being reported on, a structural feature critics argue defeats the purpose of the protection entirely. The protection has edges. The edges are where the most significant cases have landed. 29. For most of American legal history, the question of whether the Second Amendment protected an individual's right to own a firearm for private purposes did not have the answer you assume it has always had. United States v. Miller, decided in 1939, and the Supreme Court's primary Second Amendment case for nearly 70 years, upheld restrictions on sawed-off shotguns by reasoning that the amendment protects weapons bearing reasonable relation to a well-regulated militia. This collective rights interpretation governed federal courts for decades. District of Columbia v. Heller was decided in 2008, and it was the first Supreme Court ruling explicitly establishing an individual right to keep firearms for personal self-defense in the home. It was a 5-4 decision. Heller also explicitly stated, the right is not unlimited, and that many forms of gun regulation remain presumptively constitutional, including prohibitions applicable to felons, restrictions in sensitive places, and conditions on commercial sale, language that lower courts have been arguing over in hundreds of subsequent decisions ever since. McDonald v. Chicago in 2010 incorporated the Heller individual rights interpretation against state governments through the 14th Amendment. The individual right to keep a firearm for private self-defense became binding on state governments in 2010. That was 15 years ago. 30. Approximately 97% of federal criminal convictions result from guilty pleas, the vast majority through plea bargaining. Approximately 94% of state convictions follow the same path. The trial by jury, the constitutional guarantee that American civics courses treat as the centerpiece of criminal justice, is exercised in roughly 3% of federal cases. The Supreme Court acknowledged this reality directly in Loeffler v. Cooper in 2012, stating that plea bargaining is not some adjunct to the criminal justice system, but is the criminal justice system. Prosecutors use charge stacking, filing multiple overlapping charges, to create leverage that makes the sentencing exposure of a trial so catastrophic that accepting a plea to a single lesser count becomes rational regardless of actual guilt. The National Registry of Exonerations has documented hundreds of cases where individuals who later received exonerations through DNA evidence had previously pled guilty to crimes they did not commit, often to avoid trial risk on charges carrying life or death sentences. The trial penalty, the documented disparity between sentences received after trial and sentences offered in plea negotiations, averages 3 to 5 times longer in federal cases. Your constitutional right to trial by jury is waived in 97% of federal criminal cases. Both the right and the waiver rate exist in the same document without apparent tension. 31. Grand juries are constitutional safeguards. Independent citizens review the government's evidence before serious federal charges can be filed. This check exists to prevent prosecutorial overreach from reaching trial. Former New York Chief Judge Sol Wachtler once observed that a prosecutor could get a grand jury to indict a ham sandwich, which is colorful and empirically supported. Federal grand juries indict in the vast majority of cases presented to them, with indictment rates in federal grand juries documented above 99% in available studies. Grand jury proceedings are conducted in secret, with no judge presiding, no defense attorney present in the room, and hearsay evidence freely admissible under rules that would be impermissible at trial. Witnesses appearing before a grand jury cannot have their attorney present during questioning. The attorney must wait outside, and the witness must physically exit the room to consult before returning to answer. This creates substantial pressure to respond without real-time legal guidance. Grand juries investigating police conduct, including the 2014 cases involving Michael Brown in Ferguson and Eric Garner in New York, declined to indict in both instances, demonstrating that when prosecutors do not want an indictment, the grand jury declines to return one. The independent check operates independently when the prosecution wants it to. 32. Solitary confinement in American prisons is a last resort for genuinely dangerous individuals who cannot be safely managed in general population. This is the framing. On any given day, an estimated 80,000 to 100,000 people are held in solitary confinement in American prisons and jails. The Arthur Lyman Center at Yale Law School produced this figure, and it represents one of the highest rates of isolation confinement in the democratic world. The United Nations Standard Minimum Rules for the Treatment of Prisoners, adopted in 2015 and named the Nelson Mandela Rules, define prolonged solitary confinement beyond 15 days as cruel, inhuman, or degrading treatment prohibited under international human rights law. The United States voted to adopt these rules. Juveniles have been held in solitary confinement in American facilities, despite extensive evidence of acute psychological harm, including at Rikers Island in New York before a 2014 ban on juvenile solitary, in most circumstances, was implemented following litigation. Medical literature consistently associates prolonged solitary with anxiety, depression, hallucinations, and psychosis. The American Psychological Association has called for severe restriction of the practice. America put its signature on a document defining prolonged solitary as inhumane, continued using it on approximately 80,000 to 100,000 people the next day, and has done so every day since. 33. You know that biometric security is convenient because your face and fingerprint unlock your phone instantly. You may not have considered that this convenience is also a legal vulnerability that a password does not share in the same way. Courts have drawn a distinction between testimonial evidence, what you know, including a password, which reflects the contents of your mind and is protected by the Fifth Amendment, and non-testimonial evidence, what you are, including a fingerprint or face, which courts have treated more like a physical key to a lock. Several federal and state courts have found that compelling a password violates Fifth Amendment protections. Others have applied the foregone conclusion doctrine, allowing compulsion when the government already knows what it will find. Law enforcement has exploited the biometric exception in documented cases by physically placing a suspect's finger on a device during arrest, before formal questioning begins, and before an attorney can intervene. The FBI's 2016 legal battle with Apple over the San Bernardino shooter's iPhone was ultimately resolved by paying a third-party firm approximately $900,000 to crack the device, rather than litigating the compelled access question to a definitive ruling. What you know is constitutionally protected. What your face looks like exists in a significantly more contested legal space. 34. The Supreme Court banned prayer in public schools. This is what a significant portion of the American population believes happened in 1962, and it is a mischaracterization precise enough to be functionally misleading. Engel v. Vitale in 1962 banned state-composed, school-sponsored prayer, specifically a 22-word non-denominational prayer written by the New York State Board of Regents and directed by the school. Abington School District v. Schempp in 1963 extended this to school-sponsored Bible readings. Students have retained the constitutional right to pray individually and voluntarily in public schools since those decisions were issued, including praying silently, saying grace, reading religious texts during free periods, and forming religious student groups. Good News Club versus Milford Central School. In 2001, required schools to give religious student groups equal access to facilities available to secular groups. Kennedy versus Bremerton School District in 2022 ruled that a public school football coach's post-game on-field prayers were protected First Amendment expression, reversing lower court rulings and substantially muddying the distinction between private religious expression and state-sponsored religious activity. The court banned the government from writing your prayer in 1962. The space between that prohibition and private prayer in a government building has been litigated continuously for 60 years because it turns out to be considerably larger than either side expected. 35. Marijuana is simultaneously legal and a Schedule I controlled substance with no accepted medical use, and both of these statements are currently true at the same time in the same country. 24 states have legalized recreational marijuana as of 2024. The Federal Controlled Substances Act has classified marijuana as Schedule I since 1970, placing it alongside heroin and above cocaine in terms of legal restriction, a classification unchanged through decades of accumulating medical research. Federal employees and contractors working on federal projects can be terminated for marijuana use that is entirely legal under the state law where they live and work. Banks cannot fully service cannabis businesses under federal banking regulations, forcing many legal marijuana operations to conduct business almost entirely in cash, a situation that has persisted through multiple cycles of state-level legalization. The DEA announced in 2024 that it was considering rescheduling marijuana to Schedule III, which would ease but not eliminate federal restrictions. As of mid-2025, that rescheduling process remains incomplete. You can legally purchase marijuana in a state-licensed store, legally consume it at home, and legally lose your federal contractor employment for the same activity on the same day. The law contains multitudes. All of them are simultaneously enforceable. 36. Online gambling law in America was written in 1961 to stop organized crime from using telephones. and that foundational statute has been reinterpreted by two different presidential administrations, reaching opposite conclusions, producing contradictory federal court rulings that are currently unresolved. The Wire Act of 1961 targeted sports betting conducted over phone lines. The Obama administration's Department of Justice interpreted it in 2011 as applying only to sports betting, opening online casino gaming. The Trump administration's DOJ reinterpreted it in 2019 as applying to all online gambling. Federal courts produced conflicting rulings. As of 2024, online casino gambling is fully legal in only 6 states: New Jersey, Michigan, Pennsylvania, Delaware, West Virginia, and Connecticut. Daily fantasy sports platforms operated for years in a legal gray zone after the DOJ determined they fell outside the Unlawful Internet Gambling Enforcement Act of 2006, a determination many legal scholars disputed, but courts largely allowed to stand. Sports betting was federally prohibited under the Professional and Amateur Sports Protection Act until the Supreme Court struck it down in Murphy v. NCAA in 2018, giving states the right to decide individually. Your poker hand is legal in New Jersey, potentially criminal in Utah, and ambiguous in approximately 40 other states. The rulebook is being revised in real time. 37, the Supreme Court ruled in 2005 that the government can legally seize your private property and transfer it to another private owner if doing so produces economic development the government considers beneficial to the public. Kelo versus City of New London is the case. The City of New London, Connecticut, seized 15 homes in the Fort Trumbull neighborhood to hand to a private developer, building a hotel and office complex intended to complement an adjacent Pfizer research facility. The development project for which those homes were taken was never built. The Pfizer facility the project was designed to support closed in 2011. The seized land became an empty lot that remained empty for years after the Supreme Court decided the seizure was constitutionally permissible. The public backlash was significant enough that 43 states passed laws restricting economic development takings after the ruling, though legal scholars have noted many of these laws contain loopholes providing limited practical protection. Suzette Kelo's pink house, the most photographed of the seized properties, was physically relocated to another address as a preservation effort, and now serves as a monument to the case. The government took her house for a hotel that was never built on land that is still a field. The legal principle survived the project. 38, feeding hungry people is morally unambiguous. Whatever the government does or fails to do about homelessness, the act of handing someone a sandwich operates outside the jurisdiction of reasonable legal regulation. Over 70 American cities have enacted some form of restriction on public food sharing, as of 2024, according to the National Homelessness Law Center. Fort Lauderdale, Florida passed an ordinance in 2014 requiring food sharing events to be held at least 500 feet from residential areas and permitting a maximum of 2 outdoor food distribution events per year at any given location. Philadelphia banned outdoor feeding programs in city parks in 2012, forcing established charities that had operated for years to find alternative locations. A 2021 court ruling in favor of a faith-based organization challenged Philadelphia's ban but did not invalidate similar ordinances operating in other jurisdictions. Las Vegas passed an ordinance in 2006 prohibiting the feeding of indigent persons in city parks, with fines up to $1,000. A local pastor was arrested multiple times for violating the ordinance before it was eventually modified. America built a permitting system for the act of giving someone food. The sandwich has a compliance requirement. The exclusion zone is measured in feet. This is documented municipal law. 39. Your concealed carry permit, issued legally by your home state, valid under your state's laws, may become a felony the moment you cross the wrong state line. Concealed carry permits from some states are recognized by 37 other states through reciprocity agreements, but not all of them, and the reciprocity map changes as states update their agreements. A permit issued in Florida is valid in Alabama and not in California, and tracking which permits remain valid where requires consulting regularly updated charts because the landscape shifts. New Jersey's mandatory minimum sentences for unlicensed handgun possession are among the strictest in the country, requiring a minimum of 3.5 years without parole. New Jersey does not recognize out-of-state carry permits, creating a documented pattern of out-of-state gun owners facing severe prison sentences for weapons they carried legally at home. Suppressors are legal to purchase with a federal tax stamp in 42 states and entirely illegal in 8, meaning the same device, purchased legally and transported across a state line into a prohibited state, becomes a criminal possession. The Supreme Court's Bruen decision in 2022 requires lower courts to evaluate gun laws against historical analogs from 1791, applying an 18th century historical test to 21st century weapons technology in ongoing litigation with no settled conclusion. 40. The jaywalking citation you receive in one American city might cost you $1. In another city, for the identical behavior, it costs $250. The fine for walking across an empty street varies by this margin across American jurisdictions, and enforcement patterns have been so racially skewed that multiple cities have investigated their own jaywalking enforcement programs as potential civil rights violations. Jacksonville, Florida, was investigated by the United States Department of Justice after data showed black pedestrians received 55% of jaywalking citations, despite comprising 29% of the population, a disparity the DOJ characterized as potentially discriminatory. Los Angeles issued over 9,000 jaywalking citations in 2019, with enforcement concentrated in lower-income neighborhoods. The City Council voted to stop enforcement in 2022, 3 years before California's statewide decriminalization took effect. New York City's $250 jaywalking fine was acknowledged by the NYPD itself as essentially discretionary, triggered by officer observation rather than any systematic patrol strategy. Despite California's decriminalization, federal law still lists jaywalking as a violation near federal facilities, meaning the same crossing can be state legal and federally actionable depending on which building is nearby. The fine ranges from $1 to $250,000. The enforcement depends on who is watching when you cross. 41. The First Amendment protects free speech. That sentence is accurate and significantly less comprehensive than Americans typically understand it to be. Established categories of speech that receive no First Amendment protection under current United States law include incitement to imminent lawless action under Brandenburg v. Ohio from 1969, true threats, defamation, fraud, obscenity, child pornography, and speech integral to criminal conduct. Fighting words, speech that by its very utterance tends to incite an immediate breach of the peace, remain an unprotected category under Chaplinsky v. New Hampshire from 1942, though courts rarely apply it broadly. Content-neutral time, place, and manner restrictions are constitutionally permitted, meaning a city can legally prohibit amplified speech in residential areas at midnight, even if the content itself would be fully protected at noon. Several states passed social media content moderation laws attempting to require platforms to carry certain speech, producing a circuit split before the Supreme Court's Moody v. NetChoice. Ruling in 2024 sent both cases back for further review without resolving the underlying constitutional question. Free speech is the most protected right in American law and the most continuously litigated one, because its edges are where all the consequential action has always been. The Constitution guarantees almost everything. The courts spend decades arguing about where almost ends. 42. Jury duty summons pull from voter rolls. Everyone knows this. You register to vote, you accept the civic bargain, and eventually a summons arrives because of that registration. Federal courts and most state courts now compile jury pools from combined databases including voter registration, driver's license records, state identification records, tax rolls, and in some jurisdictions, utility records, meaning non-voters are regularly called for jury duty. The deliberate expansion beyond voter rolls was prompted by data showing that exclusive reliance on voter registration produced jury pools that were demographically unrepresentative of the actual community, creating a Sixth Amendment concern about the fairness of cross-section requirements. California, Texas, and New York all use driver's license databases as a primary source, making driver's license holders statistically more likely to receive summonses than non-driving registered voters in some analyses. The belief that avoiding voter registration avoids jury duty has persisted as a cultural assumption despite being factually incorrect in most jurisdictions for decades. It has been cited in surveys as a reason some eligible Americans choose not to register, suppressing civic participation based on a false premise about a different civic obligation. The DMV has been the primary jury pool source the whole time you thought you were outsmarting it. The avoidance strategy has been outdated for approximately 30 years. 43 drug-sniffing dogs are scientific instruments. A trained dog alerting to your vehicle provides law enforcement with objective evidence of contraband, grounded in biological certainty that a court can rely upon. A Chicago Tribune analysis of data from suburban police departments found that drug dogs alerted correctly in only 44% of vehicle searches, and the false alert rate was substantially higher during searches of Hispanic drivers compared to white drivers, suggesting handler expectations were influencing the animals. The Supreme Court ruled in Florida versus Harris in 2013 that a dog's alert provides sufficient probable cause for a vehicle search even without field performance data, meaning courts do not require police to prove the specific dog's documented accuracy before authorizing a search of your car. A 2011 study at the University of California, Davis demonstrated that handler expectations directly influenced dog alert behavior. When handlers believed, falsely, that contraband was present, the dogs alerted significantly more often than when handlers had no such expectation, even when no drugs existed in the search area. Residual traces of cocaine have been detected on the majority of circulated United States currency in various studies, meaning a dog could plausibly alert on almost any cash you are carrying. The probable cause machine has an error rate that varies with how confident its handler appears. 44. The Sixth Amendment guarantees the right to a speedy trial. Speedy is the word the Constitution uses. The word speedy has no defined duration in American constitutional law, and the Supreme Court has specifically and repeatedly refused to assign one. Barker v. Wingo in 1972 established a four-factor balancing test for speedy trial violations, measuring length of delay, reason for delay, whether the defendant asserted the right, and whether prejudice resulted, while explicitly declining to set any specific time limit. The Speedy Trial Act of 1974 set federal statutory deadlines of 30 days from arrest to indictment, and 70 days from indictment to trial, but those deadlines are riddled with excludable time provisions covering continuances, pretrial motions, and procedural delays that can extend them substantially. In state courts, average pretrial detention for serious felony cases routinely runs 12 to 24 months in high-volume jurisdictions. Khalif Browder spent 3 years at Rikers Island awaiting trial on a robbery charge filed when he was 16. The case was dismissed. He had been held from age 16 to 19, without a conviction under a constitutional guarantee that the trial would be speedy. The constitutional speedometer has no numbers on it. Courts have had 50 years to add some. They have declined. 45. The phrase separation of church and state appears in the First Amendment. This is one of the most repeated facts in American civic discourse, and it is wrong. The phrase appears in Thomas Jefferson's 1802 letter to the Danbury Baptist Association. The First Amendment says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, which is a different and considerably more contested formulation. Legislative prayer, opening congressional and state legislative sessions with prayer delivered by government-paid chaplains, was upheld in Marsh v. Chambers in 1983 and reaffirmed in Town of Greece v. Galloway in 2014, meaning government-employed clergy opening government sessions with explicitly religious prayer is constitutionally permitted. Kennedy v. Bremerton School District in 2022 ruled that a public school football coach's post-game on-field prayers were constitutionally protected, narrowing Establishment Clause restrictions in ways that reversed decades of precedent. The motto, "In God We Trust," appears on all United States currency, was added in 1956, and has been upheld by courts as ceremonial rather than substantive religious establishment. The wall Jefferson described in a private letter has been getting shorter in Supreme Court decisions issued at regular intervals. It remains present. It is measurably shorter than when the letter was written. 46. Trespassing is a crime. You enter someone's property without permission. You are a trespasser. You have committed a violation. Criminal trespass typically requires proof that the trespasser knew they lacked permission and remained despite being asked to leave or despite clearly posted notice. Inadvertent entry onto poorly marked private land is usually a civil matter rather than a criminal offense. The attractive nuisance doctrine in tort law creates a legal duty for property owners to prevent children from accessing dangerous features like swimming pools or abandoned machinery on their own land, meaning the property owner can bear civil liability even when a child trespasses onto their property. Several states have enacted agricultural facility trespassing laws, creating enhanced criminal penalties for journalists or activists who enter farming operations under false pretenses. Laws that have faced First Amendment challenges with mixed outcomes in different circuits. North Carolina passed legislation making it a criminal trespass to access any non-public area of a business without permission with intent to record, a law the Fourth Circuit struck down in 2022 as a content-based speech restriction. Trespassing is civil, criminal, agricultural, journalistic, and First Amendment adjacent, depending on who is trespassing, what they intend to document, and whether they brought a camera. The no trespassing sign is the simplest element of an extremely complicated sentence. 47. Bankruptcy is the legal reset button. Your debts are discharged. You emerge from the process with a clean slate and the opportunity to begin again. Student loans are almost entirely non-dischargeable in bankruptcy under federal law, unless a debtor can demonstrate undue hardship under a three-part legal test that courts have applied so narrowly that fewer than 0.1% of student loan borrowers who file bankruptcy have successfully discharged their loans through that mechanism. The Bankruptcy Abuse, Prevention and Consumer Protection Act of 2005 added a means test requirement for Chapter 7 liquidation bankruptcy, requiring filers to demonstrate income below state median or pass a disposable income calculation, dramatically reducing the availability of the most comprehensive form of debt relief. A Chapter 7. Bankruptcy remains on your credit report for 10 years. A Chapter 13. Filing remains for 7. Alimony, child support, most tax debts, criminal restitution, and debts incurred through fraud are all non-dischargeable categories, meaning bankruptcy resolves certain financial obligations while carefully exempting the ones most likely to have created the financial crisis requiring bankruptcy in the first place. The reset button works on some of your problems. It was specifically engineered to avoid the largest ones. The Fresh Start has a detailed exclusion list. 48, you bought the land. Everything above it is your airspace. Everything below it is your mineral rights. This is the foundational understanding of real property ownership in America, and the second half of it is wrong for a substantial percentage of American landowners. Mineral rights in the United States are a separate, severable property interest that can be and routinely has been owned by an entirely different party from the surface owner. Historical land sales across much of Texas, Oklahoma, and the oil-producing American West separated mineral rights from surface rights decades or centuries ago. The current surface landowner may have no legal claim to whatever is extracted beneath their property, and may have never known this when they purchased. The legal doctrine of dominant estate generally gives mineral rights holders the right to use reasonable amounts of the surface to access minerals, meaning a drilling company can legally enter your property, construct infrastructure, and extract resources without obtaining your permission if they hold the mineral rights beneath your land. Hydraulic fracturing has made this acutely visible. Landowners have discovered they own the surface of land being industrially drilled by mineral rights holders. They have never met with limited legal recourse for disruption or environmental impact on their surface property. You own the yard. Someone else owns everything under it. They can show up with equipment. 49. Your email requires a warrant for law enforcement to access. The Fourth Amendment protects your private communications. This is what you understand to be true, and for a significant portion of the Internet era, it was not the legal standard governing your inbox. The Electronic Communications Privacy Act was passed in 1986, when email storage on servers was assumed to be temporary, and emails older than 180 days were legally treated as abandoned documents accessible to law enforcement with only a subpoena, not a warrant. This law was written before the commercial internet existed, before cloud storage was a concept, before keeping years of email in a server was a routine feature of communication. The Sixth Circuit ruled in United States versus Warshak in 2010 that the Fourth Amendment requires a warrant for email content regardless of the 1986 statute. But this ruling governed only the Sixth Circuit, creating a split with other jurisdictions. The Email Privacy Act, which would have required warrants for all stored email, passed the House unanimously in 2016 and was never voted on in the Senate. As of 2025, comprehensive email privacy reform at the federal level remains incomplete. The law governing your inbox was written the year Windows 1.0 was released. It was written for a world that no longer exists. 50. Castle doctrine is real. Your home is your castle. If someone breaks in, you can defend it. Stand your ground laws extend this principle. But what you can actually do legally, in which rooms, under which threat assessment, in which state, is so variably defined that the same defensive action is justified in one jurisdiction and a felony in the one next to it. Approximately 30 states have stand your ground laws as of 2024, allowing force without retreat in any location where you have a legal right to be. The remaining states impose a duty to retreat in some circumstances, meaning the same perceived threat in Florida and Connecticut produces different legal obligations. Colorado's Make My Day law, one of the earliest Castle Doctrine statutes passed in 1985, has been interpreted narrowly by some courts as applying only inside the physical dwelling, not attached garages or surrounding property in certain rulings. Even in states with strong Castle Doctrine protections, civil liability from the intruder's estate remains possible, since a civil wrongful death suit requires only a preponderance of evidence rather than proof beyond reasonable doubt. Your castle's legal protection has footnotes specific to your state, your room, and whether the civil plaintiff can afford a lawyer after the criminal proceedings conclude. 51. Miranda warnings were addressed 2 items ago, but the right to your one phone call and the right your lawyer keeps everything secret. Both deserve the same scrutiny. So here's the complete picture of what attorney-client privilege actually protects, and what it specifically does not. The privilege is one of the most robust protections in American law, and it has 3 significant exception categories that can eliminate it. The crime-fraud exception removes privilege from any communication made in furtherance of a future crime or fraud. If you tell your attorney about a plan to commit a crime and request assistance executing it, that communication is not privileged and can be compelled in court. The privilege can be inadvertently waived through disclosure to third parties. If you discuss your attorney's advice with a friend, a business associate, or a family member in a state without spousal privilege extension, the privilege may be deemed waived for those communications. In 2018, a federal judge approved an FBI raid on Michael Cohen's office, seizing privileged attorney-client communications on the grounds that a substantial portion of Cohen's legal work fell under the crime-fraud exception, demonstrating the exceptions application in the highest profile possible context. The vault is real. It is the most protected vault in American law. It has doors. The doors have specific conditions under which they open without your permission. 52. Electoral college electors vote for whoever won their state. That is their function. It is automatic and ceremonial, and the outcome is predetermined by the popular vote results. In the 2016 presidential election, 7 electors voted for someone other than the candidate who won their state, the most faithless electors in any election since 1872. 2 Texas electors cast votes for John Kasich and Ron Paul instead of the candidate who carried Texas. Several Clinton electors cast protest votes for alternative candidates. Chiafalo versus Washington and Colorado, Department of State versus Baca, were decided together by the Supreme Court in 2020, ruling that states may constitutionally enforce laws binding electors to the state's popular vote outcome. The court did not require states to enact such laws. As of 2024, approximately 33 states and the District of Columbia have binding elector laws. The remaining states have no such requirement, meaning electors from those states remain free to vote for any constitutionally eligible person they choose. The Constitution itself provides no instruction on faithfulness, an omission the founders apparently left intentional to preserve independent judgment. The mechanism that selects the American president includes human beings whose votes can legally go anywhere in nearly a third of states. The college has been freestyle the entire time. 53. The TSA is there to keep planes safe. Every item confiscated, every shoe removed, every liquid discarded represents a genuine security measure protecting air travelers from documented threats. In 2015, the Department of Homeland Security's Inspector General conducted covert testing at dozens of airports and found that undercover agents successfully smuggled mock explosives and weapons through TSA security checkpoints in 67 out of 70 attempts, a 95% failure rate. A follow-up test in 2017 showed the failure rate had not substantially improved. The 311 liquid rule, requiring containers of 3.4 ounces or less in a single quart-sized bag, was implemented in August 2006 following the disruption of a plot to detonate liquid explosives on transatlantic flights. The restriction has never been updated, despite significant changes in both threat assessment and available scanning technology in the nearly 2 decades since. The TSA's SPOT program, which employed behavioral detection officers to visually screen passengers for suspicious behavior, cost approximately $900 million over a 10-year period. A Government Accountability Office report found no scientific evidence that the techniques reliably identify threats. The agency that makes you throw away your water missed the simulated bomb 95% of the time. The water is gone. The threat assessment remains a separate matter entirely. 54. If you are convicted of a felony in America, you lose your right to vote. That is the consequence of committing a serious crime, and the legal framework applies consistently to everyone who has committed one. Maine and Vermont have never disenfranchised convicted felons at any point in their history. Individuals currently imprisoned for any crime, including murder, retain full voting rights in those 2 states. Florida voters passed Amendment 4 in 2018 by 64%, restoring voting rights to most people with prior felony convictions after sentence completion. The Republican-controlled legislature then passed implementing legislation requiring payment of all outstanding fines, fees, and restitution before rights were restored. A federal court described this as a pay-to-vote scheme before a narrower appellate ruling allowed the restriction to stand. Approximately 5.2 million Americans were disenfranchised due to felony convictions as of 2022, according to the Sentencing Project. Roughly half were not incarcerated, but were on probation, parole, or had completed sentences in states with extended disenfranchisement provisions. The Supreme Court upheld state felon disenfranchisement in Richardson versus Ramirez in 1974. The same felony conviction produces no voting loss in Vermont and potentially lifetime disenfranchisement in other states. The map was drawn by 50 separate legislatures with no coordination requirement. 55. Certain words are banned from broadcast television. The FCC maintains a list. The prohibition is categorical and permanent and applies uniformly across the medium. The FCC regulates indecent content only during specific hours, and the legal foundation of that regulation has been challenged multiple times without final resolution of the underlying constitutional question. FCC versus Pacifica Foundation. In 1978, upheld FCC authority to regulate indecent content on broadcast during hours when children are likely in the audience, specifically 6 in the morning to 10 at night. After 10, indecent content is legally permitted on broadcast television. FCC versus Fox television stations in 2012 involved fleeting expletives during live award broadcasts and was decided on due process grounds rather than First Amendment grounds, leaving the underlying constitutional question unresolved. The FCC imposed a $550,000 fine on CBS following the Super Bowl halftime show in 2004. The Third Circuit vacated the fine in 2012, ruling the FCC had acted arbitrarily. Cable and streaming platforms have never been subject to FCC indecency regulations, meaning HBO, Netflix, and every streaming service have always operated entirely outside this framework. The banned words are technically prohibited for 16 hours a day on channels a shrinking percentage of Americans watch. After 10, broadcast is free. Streaming was always free. 56. A private security guard in a uniform with a badge represents authority. When someone in that uniform asks for your identification, the reasonable assumption is that providing it is legally required. Private security guards are not law enforcement officers. They have no more legal authority to compel your identification than any other private citizen on the street. They can ask you to leave private property, and if you refuse, they can contact actual law enforcement. They cannot detain you for extended periods, conduct searches, or legally require you to produce identification. The merchant's privilege, also called shopkeeper's privilege, allows retail employees to briefly detain someone they have reasonable cause to believe has shoplifted, but only for a reasonable time and only in a reasonable manner. It does not authorize demanding identification. TSA agents are federal employees whose authority exists specifically within the airport security screening area they operate. They cannot arrest you, must call law enforcement to do so, and have no jurisdiction beyond that designated space. The uniform is doing most of the persuasive work in these interactions. The legal authority behind it is considerably smaller than the uniform implies. When a private security guard asks for your identification, you are being asked. You are not being legally required. These are different things, and the difference matters. 57. If you ask an undercover police officer whether they are a cop, they are legally required to tell you the truth. The rule is a basic protection. Law enforcement cannot entrap you by lying about their identity when directly asked. No federal law, no constitutional provision, and no Supreme Court ruling requires undercover law enforcement to identify themselves when asked during an active undercover operation. Courts have specifically and repeatedly rejected this argument when raised as a defense in criminal cases. DEA, FBI, ATF, and local law enforcement routinely conduct long-term undercover operations lasting months or years, during which agents maintain cover identities, build personal relationships with targets, and explicitly deny being law enforcement when asked directly. All of this is legally permitted. The entrapment defense, that sounds like it should protect you, requires demonstrating government inducement to commit a crime you were not predisposed to commit, which is a completely different legal standard from whether the officer admitted their identity when you asked. The must-identify rule likely persists culturally because some jurisdictions require uniformed officers to identify themselves in non-undercover contexts, and this limited requirement has been generalized into a universal rule that does not exist. You can ask the undercover officer directly. He can say no. Both of you understand what just happened. One of you committed a crime. 58. Copyright protects your creative work the moment you create it, and that protection is permanent. The original Copyright Act of 1790 provided 14 years of protection with a 14-year renewal option. Congress has extended copyright terms 11 times since 1962. The current term for works created after 1978 is the life of the author plus 70 years, or 95 years for works made for hire, a duration so extended from the original framework that comparing the two requires acknowledging they share only the category name. The Copyright Term Extension Act of 1998 was nicknamed the Mickey Mouse Protection Act by critics because it was passed shortly before early Mickey Mouse films would have entered the public domain, retroactively extending existing copyrights by 20 years. The Supreme Court upheld the retroactive extension in Eldred v. Ashcroft in 2003 in a 7-2 decision. Justices Breyer and Stevens dissented, arguing that retroactively extending existing copyrights provides no incentive for additional creative work, since the work already exists and serves only to extend corporate monopolies beyond any rational justification. Fair use is a 4-factor test with no bright lines, meaning whether your specific use qualifies requires litigation that most individuals cannot afford. The temporary monopoly copyright was designed to create, now lasts decades past the creator's death. The word temporary is doing considerable work. 59. The FDA tests food additives and approves them before they reach your food. That is the regulatory system that stands between you and untested chemical compounds in your diet. A significant category of food additives enters the American food supply under the generally recognized as safe designation, a classification that companies can self-determine without notifying the FDA or submitting to any agency review. The GRAS exemption was created by the Food Additives Amendment of 1958 to cover substances with established safety records, but the FDA itself has acknowledged that companies may make independent GRAS determinations using expert panels they select and fund themselves without any agency involvement in the process. A 2010 Government Accountability Office report found that the FDA had little assurance of the safety of many chemicals added to food because the self-determined GRAS pathway allows companies to bypass pre-market review entirely. The Environmental Working Group has identified over 1,000 additives that entered the food supply under GRAS determinations the FDA never reviewed. Several substances approved as GRAS in the United States have been banned or restricted in the European Union, including brominated vegetable oil, potassium bromate, and azotocarbonamide, used in American food products for years after being restricted elsewhere. The label says what is in your food. It does not say who decided it was safe or whether that decision involved the agency you assumed was making it. 60. Tipping is voluntary. It is a cultural courtesy extended for good service. The restaurant pays its staff. Your tip is optional recognition of work well performed. In states that use the federal tipped minimum wage, restaurant servers are legally paid as little as $2.13 per hour by their employer. The federal tipped minimum wage has been $2.13 since 1991, the longest period without an increase in any federal wage provision in the country's history. The tip credit mechanism allows employers to count customer tips toward their minimum wage obligation. If tips do not bring a worker's total hourly earnings to $7.25, the employer is required to make up the difference. But enforcement of this backstop has been widely documented as insufficient in practice. 7 states have eliminated the tipped minimum wage distinction entirely, requiring all workers, including tipped employees, to receive the full state minimum wage. Studies of tipping behavior consistently show that tip amounts correlate with factors unrelated to service quality, including physical appearance and demographic characteristics of the table, undermining the premise that tipping is performance-based. Australia, Japan, and most of Europe pay restaurant workers a full minimum wage without a tipped credit system. The tip is voluntary. In the same sense, oxygen is optional. Technically accurate. Practically, the federal government has permitted $2.13 since the year before Bill Clinton took office. 61. You have the absolute constitutional right to represent yourself in court. Ferretta v. California in 1975 established this right explicitly. What the court also noted is that it can be overridden if the defendant is not competent to conduct a basic defense, and courts have subsequently allowed self-representation to be denied when defendants use it as a deliberate delay tactic or cannot maintain basic courtroom decorum. Indiana v. Edwards in 2008 held that courts may require represented counsel even for defendants found competent to stand trial, recognizing that the competency standard for effective self-representation may legitimately be higher than the standard for simply participating in a trial. The standby counsel system, where a judge appoints an attorney to assist without fully representing a pro se defendant, creates a gray zone where the defendant is theoretically in control while an attorney participates, producing appellate questions about whether the defendant's rights were adequately protected in either direction. Pro se defendants in federal court are convicted at substantially higher rates than represented defendants in comparable case studies. The legal system is built on procedural rules, evidentiary standards, and strategic knowledge that take 3 years of professional training to acquire at minimum. You have the absolute right to represent yourself against someone who practices this professionally every day, in a system built by people who spent years learning its rules. The right is real. The outcome data is its own counter-argument. 62. Nonprofit organizations do not make money. The mission is the point. Executives at nonprofits accept reduced compensation because they believe in the cause rather than the profit. Nonprofit status under IRS Section 501(c)(3 prohibits distribution of surplus revenue to private shareholders. It does not prohibit generating surplus revenue. It does not cap executive compensation. It does not require financial modesty of any kind from the people running the organization. In 2019, 11 college football coaches at public universities earned more than $5 million annually through their institution's nonprofit athletic programs. Numerous hospital CEOs earn over $3 million annually through nonprofit hospital systems. The NCAA operated as a nonprofit organization under Section 501(c)(6) until 2023, when it voluntarily surrendered that status. During its nonprofit years, the NCAA generated over $1 billion in annual revenue, primarily from broadcasting agreements for athletic events performed by unpaid student athletes. Donor-advised funds allowed donors to take an immediate charitable tax deduction while retaining advisory control over when and to whom the donated funds are actually distributed, sometimes holding them for years or indefinitely without any distribution requirement. Nonprofit means the profit does not leave the organization as shareholder distributions. It stays inside. It funds the expansion, compensates the executives, and builds the endowment. The word is doing considerably more work than its definition suggests. 63. When you vote for president, you are voting for the president. The votes are counted, the winner is determined, and that person becomes president. Americans do not directly vote for president. They vote for a slate of electors who then cast the actual votes that constitute the election. Article 2 of the Constitution gives state legislatures the authority to determine how their electors are appointed. The popular vote system Americans use today is a tradition established by states, not a constitutional requirement. State legislatures theoretically retain the power to appoint electors directly without holding a popular vote at all, a legal reality the Supreme Court acknowledged without resolving in Bush versus Gore in 2000. The National Popular Vote Interstate Compact, an agreement among states to award their electoral votes to the national popular vote winner, has been signed into law by states with a combined 209 electoral votes as of 2024. It takes effect only when participating states reach 270 total electoral votes, a threshold not yet achieved. 3 times in modern history, the candidate who received fewer total popular votes won the Electoral College and became president. This outcome is mathematically predictable under the winner-take-all system and has been modeled extensively by political scientists. You vote for electors. The electors vote for president. The state legislature decides the rules for both steps. 64, Chapter 7. Bankruptcy liquidates your non-exempt assets to pay creditors and leaves you with a clean financial start. The exemptions, protecting what you keep, vary so dramatically between states that the same bankruptcy filing produces entirely different outcomes depending on where you happen to live. Texas and Florida have unlimited homestead exemptions, meaning a debtor can protect a home of any value from bankruptcy liquidation regardless of how much equity it holds. This is why O.J. Simpson purchased a home in Florida following his civil judgment, and why wealthy individuals have historically moved expensive real estate purchases to exemption-friendly states before filing. Critics called this the millionaire's loophole, documented in cases where individuals transferred substantial assets into home equity in unlimited exemption states shortly before filing, effectively shielding millions from creditor recovery. Federal bankruptcy exemptions protect a homestead equity of approximately $27,000, a vehicle worth approximately $4,000, and household goods up to approximately $14,000 in aggregate, with states permitted to substitute their own exemption schedules in place of the federal ones. Retirement accounts, including 401k plans and IRAs, are generally protected in bankruptcy under federal law regardless of size, meaning a person with substantial retirement savings can discharge debt while retaining those assets entirely. The fresh start is real. Its terms depend significantly on which state you filed in. 65. Birthright citizenship is in the 14th Amendment, and it is absolute. If you are born on American soil, you are an American citizen. Children born to accredited foreign diplomats and consular officers are explicitly excluded from birthright citizenship under the diplomatic immunity framework because they are considered born not subject to the jurisdiction of the United States, the qualifying clause in the amendment. United States versus Wong Kim Ark in 1898 is the Supreme Court's primary birthright citizenship case, holding that a child born in San Francisco to Chinese parents was a citizen despite Chinese Exclusion Act restrictions on Chinese immigration. Legal scholars continue to debate whether this case fully resolves the question of children born to unauthorized immigrants, since Wong Kim Ark's parents were legal residents, meaning the factual basis of the ruling does not map precisely onto the contested modern question. Executive Order 14,160, signed by President Trump in January 2025, attempted to restrict birthright citizenship for children of unauthorized immigrants and certain visa holders. The order was immediately challenged and blocked by multiple federal courts, with constitutional litigation ongoing as of mid-2025. The 14th Amendment has been the law for over 150 years. It is currently in active federal litigation about what it means. Both of these facts are simultaneously accurate. 66. Hate speech is illegal in America. Laws against it exist. Targeting people based on race, religion, gender, or other protected characteristics through speech is a criminal offense. The United States has no general hate speech law. The First Amendment protects most offensive, hateful, and bigoted speech from government censorship, making America a significant outlier among democratic nations in this specific area of legal policy. Hate crime laws, which exist federally and in most states, enhance penalties for crimes committed because of a victim's protected characteristics. They criminalize the underlying conduct, such as assault or vandalism, not the speech itself. Speech is used as evidence of motive, not as the criminal act. The Supreme Court struck down content-based hate speech regulations in R.A.V. versus City of St. Paul in 1992, Maddle versus Tam in 2017, and narrowed the true threats, exception in Counterman versus Colorado in 2023. Canada, Germany, France, the United Kingdom, and the European Union all have laws criminalizing specific categories of hate speech, including Holocaust denial and incitement to hatred, categories of speech fully protected in the United States. Social media platform content moderation restricts hate speech as private action, which is constitutionally permitted private conduct rather than government censorship. The hate speech law Americans assume exists has never existed. The hate crime enhancement for the brick through the window is a different law. 67. The Supreme Court must hear your case if you exhaust all lower court options and file a petition. That is what having a highest court means. The Supreme Court receives approximately 7,000 to 8,000 petitions annually and grants certiorari in approximately 60 to 80 of them, less than 1% of all requests. The court has no obligation to explain why any petition is denied, and denial carries no precedential value. It does not signal agreement with the lower court ruling. It means the court declined to review it, and the lower court decision stands as the final word on your case without comment or explanation from the nation's highest judicial body. The Rule of Four, an informal practice requiring at least 4 justices to vote to grant certiorari, means a petition can be denied even if 4 justices believe the lower court was wrong, as long as 4 votes are not assembled for the procedural grant threshold. Prisoners and individuals without attorneys file a disproportionate share of petitions. The informa pauperis docket, for those who cannot afford filing fees, is substantially larger than the paid docket, but has a grant rate approaching statistical rounding error. The highest court in the land receives 7,000 applications to perform its highest court function and processes fewer than 80. Most applications are declined. None of the declinations require explanation. 68. Marijuana's placement on the federal drug schedule reflects the scientific consensus on harm, abuse potential, and medical value as assessed by experts operating within a rational regulatory framework. John Ehrlichman, Nixon's domestic policy chief, stated in a 1994 interview published in Harper's Magazine in 2016 that the war on drugs was designed to associate specific political and racial communities with specific substances, and that by criminalizing both heavily, those communities could be disrupted. This was an explicit admission of political rather than scientific intent in the design of the policy. The Schaefer Commission, appointed by Nixon specifically to study marijuana's effects, recommended in 1972 that marijuana be decriminalized. Nixon rejected his own commission's report and maintained marijuana as Schedule 1. MDMA was placed on Schedule 1 in 1985 over the objection of a DEA administrative law judge who ruled it did not meet the criteria. The DEA overrode the ruling. The FDA granted MDMA breakthrough therapy status in 2017 for PTSD treatment, a designation indicating substantial improvement over available therapies may be possible, creating the official position that a substance with no accepted medical use was simultaneously being fast-tracked for medical use by a different federal agency. The schedule is a federal document. It is not a scientific one. These have never been the same thing. 69. America has a firm legal separation between the military and domestic law enforcement. The Posse Comitatus Act draws a clear line. Soldiers are not police. That boundary is maintained by statute and respected by both institutions. The Posse Comitatus Act of 1878 prohibits using the Army and Air Force as domestic law enforcement tools. The Navy and Marine Corps are covered only by Department of Defense regulation, not the statute itself. The Coast Guard is explicitly exempt. National Guard units operating under state authority in Title 32 status are entirely outside the Act's scope, meaning the largest deployable armed force available to governors operates without Posse Comitatus restrictions by design. The 1997 Defense Authorization Act established the 1033 program, which has transferred over $7.4 billion worth of surplus military equipment to local law enforcement agencies, including mine-resistant vehicles, grenade launchers, and military-grade surveillance systems. The Insurrection Act of 1807 gives the President explicit authority to deploy active-duty military for domestic law enforcement and has been invoked over 30 times in American history, most recently during the 1992 Los Angeles riots. The separation between soldiers and police exists in statute. It does not cover the Marines in statute, can be suspended by the President, and did not prevent transferring $7 billion in gear to the local sheriff. The line is real. It has the structural integrity of a strong suggestion. 70. Stalking laws protect victims comprehensively. If someone is following you, harassing you, threatening you across state lines, the legal framework responds with consistent and enforceable protections, regardless of where you or the stalker happen to be. The Violence Against Women Act requires states to honor restraining orders issued by other states under full faith and credit provisions, but enforcement requires local law enforcement to proactively recognize and honor the foreign order, a process that has broken down in documented cases resulting in serious violence against victims who believed they were protected. The Interstate Stalking Punishment and Prevention Act makes crossing state lines with intent to stalk a federal crime, but demonstrating that intent when a stalker uses digital means is difficult because digital communications technically cross state lines automatically with every transmission. Cyberstalking laws at the state level vary enough that online harassment clearly criminal under one state statute exists in a legal gray zone under another's, depending on where each party is physically located when the communication occurs. GPS tracking of a victim's vehicle by a private individual remained a civil, rather than criminal matter in many jurisdictions until state-by-state tracker laws began passing in recent years. A restraining order is constitutionally required to be enforced everywhere. It is practically enforced inconsistently everywhere. The protection crosses state lines in theory. The stalker crosses them in a car. 71. Law enforcement cannot lie to you during an interrogation. The legal system requires honesty from the people operating it. If police tell you they have evidence they don't have, that's a violation of your rights and renders any resulting confession inadmissible. Frazier v. Cupp in 1969 established that police deception during interrogation does not automatically render a resulting confession involuntary or inadmissible. Since that ruling, courts have upheld confessions obtained after police falsely claimed to have DNA evidence, fabricated eyewitness identifications, invented co-conspirator confessions, and presented non-existent forensic test results as established fact. The Reid technique, the most widely used interrogation method in American law enforcement, explicitly trains interrogators to use deception, including false evidence claims, as a core interrogation tool. Researchers studying false confessions have criticized the technique for producing unreliable admissions, particularly from juveniles, people with cognitive disabilities, and individuals in prolonged high-stress interrogation conditions. Meanwhile, 18 United States Code, Section 1001, makes it a federal crime to knowingly make any materially false statement to a federal official, including involuntary conversations with investigators, not only under oath. Police can tell you your friend already confessed when he did not. If you lie in response, you have committed a federal crime. They have not. This asymmetry is documented, Supreme Court endorsed, and actively taught in training academies. 72. Whatever you tell your attorney is protected by privilege. The confidentiality is absolute. Your lawyer cannot disclose it. The protection holds regardless of what you said or what you subsequently did with the information you received. Attorney-client privilege is one of the most robust legal protections in American law and has documented exception categories under which it disappears entirely. The crime-fraud exception removes privilege from any communication made in furtherance of a future crime or fraud. If you ask your attorney for assistance planning something that turns out to be criminal, that conversation is not privileged and can be compelled in proceedings against you. The privilege can be inadvertently waived by disclosing your attorney's advice to third parties who are not covered by the privilege, including friends, business associates, and family members in states without extended spousal privilege provisions. The privilege belongs to the client and can be waived through careless disclosure without the client realizing they have done it. In 2018, a federal judge approved an FBI raid on the office of Michael Cohen, then personal attorney to a sitting president, seizing privileged attorney-client communications after determining that a substantial portion of Cohen's legal work fell under the crime-fraud exception. The vault protecting your most sensitive legal communications is real and well constructed. It has specific doors. The doors have specific conditions under which they open without requiring your agreement. 73. Your Social Security number is a unique, protected identifier assigned specifically to you. Agencies handle it carefully. Distributing it is a serious matter with serious consequences for those who mishandle it. Until 2011, Social Security numbers were assigned using a formula that encoded the state of issuance in the first 3 digits, a group code in the next 2, and sequential numbers in the final 4, making the structure of your number partially predictable, using publicly available information about your birth. A 2009 Carnegie Mellon study published in the Proceedings of the National Academy of Sciences demonstrated that researchers could predict complete Social Security numbers for individuals born after 1988 using only their date and state of birth, with accuracy rates above 50% for residents of smaller states. The Social Security Administration switched to randomized assignment in 2011 specifically because of this documented vulnerability. Approximately 450 million Social Security numbers already issued under the old predictable system retain their original formats and cannot be changed without meeting an extremely high bar of documented ongoing harm. Unlike financial account numbers, your Social Security number is not rotated after compromise. The most sensitive identifier in American financial life was assigned through a publicly reversible formula for 70 years. The secret was always reconstructible. The internet made reconstruction faster. 74. If you bought a movie, a book, or a game through a digital platform, you own it. You paid money. The transaction produced ownership. What you actually purchased in almost every digital content transaction in America is a license granting you non-exclusive, non-transferable access to content that remains owned by the platform or rights holder and can be revoked, modified, or rendered inaccessible under terms you agreed to in a document you did not read. Microsoft announced in 2023 that it would shut down its movies and TV store, revoking access to purchased content for affected users, a move legally permitted under its terms of service. Amazon's Kindle terms explicitly state that customers acquire a non-exclusive, non-transferable right to use purchased books, meaning you cannot legally resell, lend beyond built-in features, or transfer a book you paid for. The first sale doctrine allowing resale of physical books, records, and DVDs does not apply to digital licenses under current federal copyright interpretation, eliminating the entire secondary market that exists for physical media. In 2009, Amazon remotely deleted copies of George Orwell's 1984 from customers' Kindle devices following a licensing dispute. The book about surveillance and control was recalled from private devices without consent, legally, because it had only been licensed. The irony was complete. The legal position was sound. 75. HIPAA is the gold standard of American medical privacy. Your health information is protected and cannot be shared without your explicit consent. The Health Insurance Portability and Accountability Act contains a law enforcement exception allowing covered entities, including hospitals and physicians, to disclose medical information to law enforcement pursuant to a court order, warrant, or administrative request without patient consent, and in some circumstances without patient notification that the disclosure occurred. The treatment, payment, and operations provision allows health information to be shared among healthcare providers, insurance companies, and business associates involved in your care without requiring specific consent for each individual disclosure, meaning a hospital's billing contractor, transcription service, and IT vendor may all access your protected health information under this provision. Business associates account for the majority of large-scale health data compromises documented by the Department of Health and Human Services Office for Civil Rights, meaning the third parties granted access under your privacy law are the primary source of its violations. HIPAA does not apply to entities that are not covered entities. Life insurance companies reviewing health questionnaires, employers processing disability accommodation requests, and app developers offering wellness tools are frequently outside HIPAA's scope entirely. HIPAA is the law that requires healthcare workers to whisper at the front desk and simultaneously has 12 statutory exceptions that allow your diagnosis to travel to recipients you would not have approved. Both of these are the same law. 76. The public defender system provides everyone with equal legal representation, regardless of their financial resources. The Sixth Amendment guarantees counsel. The quality of that counsel is constitutionally sufficient. The American Bar Association has documented public defender caseloads routinely exceeding 500 felony cases per attorney per year in some jurisdictions. The recommended maximum for competent representation is approximately 150 felony cases annually. The gap between those numbers is where the constitutional guarantee meets the funding reality. In 2022, the Louisiana Public Defender Board declared a statewide public defense crisis and formally requested that courts stop appointing new cases that public defenders lacked the capacity to handle, a public institutional acknowledgement that the constitutional right was not being practically met within that state's system. The average time a public defender spends with a client before trial has been documented at under 1 hour in some high-volume jurisdictions. Private criminal defense attorneys may bill dozens of hours per comparable case. Public defense funding in most states derives from court fees paid by convicted defendants, a structural incentive that creates pressure toward plea agreements rather than trials, and that dries up when criminal justice reform reduces conviction rates. The Sixth Amendment guarantees you a lawyer. The funding system guarantees that lawyer has approximately 489 other people to represent this year simultaneously. The right is absolute. The implementation has a per-attorney capacity problem that no legislature has nationally resolved. 77 non-compete agreements cannot stop you from working in your field. That is restraint of trade. Courts do not enforce provisions that prevent people from earning a living in their area of expertise and experience. As of 2023, an estimated 30 million American workers, approximately 1 in 5 employed people, were covered by non-compete agreements. This includes workers earning less than $15 per hour in food service, security, and personal care industries, where the competitive intelligence rationale for non-competes is difficult to articulate with a straight face. Jimmy John's sandwich chain faced regulatory action in Illinois and New York for requiring hourly sandwich workers to sign agreements prohibiting them from working for any competitor within 2 miles for 2 years after leaving employment. The FTC issued a rule in April 2024 effectively banning most non-compete agreements nationally. A Texas federal court blocked the rule's implementation in August 2024, leaving the regulatory landscape in active legal limbo. State law varies from California, North Dakota, Minnesota, and Oklahoma, which effectively ban non-competes, to Florida, which explicitly favors their enforcement, to most states, which apply a reasonableness test, producing inconsistent outcomes across similar cases. A sandwich worker in a suburb was contractually prohibited from making sandwiches within 2 miles. A federal agency tried to end that arrangement nationally. A federal court stopped the agency. The sandwich clause persists. 78. Debtor's prison was abolished. You cannot be imprisoned for failing to pay a debt in America. That protection was established and is legally settled. While traditional debtor's prison is illegal, a functional equivalent operates through contempt of court proceedings triggered by missed appearances in debt collection cases. When a creditor sues and obtains a judgment, courts can issue summonses requiring the debtor to appear and disclose assets. Failure to appear results in a bench warrant and arrest for contempt of court, not technically for the debt itself, but effectively because of it. 21 states allow judges to issue arrest warrants for failure to appear in civil debt collection proceedings. The Department of Justice's 2015 investigation of Ferguson, Missouri, found that the municipal court system had issued warrants and imprisoned residents primarily for failure to pay traffic fines and court fees, a mechanism the DOJ characterized as a system designed to generate revenue from the city's most financially vulnerable residents. Medical debt, the leading cause of personal bankruptcy in the United States, has produced arrest warrants in multiple documented cases where patients failed to respond to court summons they sometimes never received due to relocation or improper service. You cannot be jailed for your medical debt. You can be jailed for missing the court date where your medical debt was under discussion. The legal distinction is meaningful. The practical experience of the jail cell is identical. 79. Traffic laws apply equally to everyone. The speed limit says the same number regardless of who is driving. A stop sign requires the same response from every vehicle. The law is the text on the sign, and the sign does not know anything about the driver. Stanford University's Open Policing Project analyzed over 100 million traffic stops from across the United States and found that Black and Hispanic drivers were stopped at higher rates than white drivers. The disparity reduced measurably after dark, when officers could not easily determine a driver's race from a moving vehicle, providing statistical evidence that the disparity was not explained by differences in actual driving behavior between groups. The Department of Justice's 2015 investigation of Ferguson, Missouri, found that Black drivers accounted for 85% of vehicle stops, despite comprising 67% of the population, were more than twice as likely to be searched, despite being 26% less likely than white drivers to have contraband found during those searches, and received 90% of citations issued. Several police departments, including those in Vermont, Pittsburgh, and Louisville, have implemented mandatory race data collection for traffic stops, producing internal datasets confirming disparities that then triggered departmental reform efforts. The speed limit sign contains identical information for every driver. The statistical probability of enforcement for the same violation is not identical. Both of these facts are documented in federal investigations and peer-reviewed academic research. 80. Your digital purchases are private. What you do online is your business. Your private social media profile is visible only to the people you allowed to see it. Courts in civil litigation, including personal injury claims, divorce proceedings, and employment discrimination cases, have routinely ordered parties to produce the contents of their private social media profiles as discovery, applying standard relevance analysis rather than any privacy-based exception. Courts have rejected privacy objections on the grounds that no reasonable expectation of privacy exists in communications shared with any third party, regardless of the platform's privacy settings. At least 20 states have passed laws prohibiting employers from requiring social media passwords from employees or job applicants. In the remaining 30 states, password demands as a condition of employment may be legally permissible. The Stored Communications Act requires legal process, including subpoenas, court orders, or warrants, depending on content type, before law enforcement can access private social media content, but provides a mechanism for that access without the user's knowledge or consent. Snapchat retains metadata, and in some cases, content server-side for periods of time, and has responded to tens of thousands of law enforcement requests annually, according to its published transparency reports. Your private account settings communicate your preferences to other users. They do not communicate those preferences to opposing counsel, your employer, or investigators with appropriate legal process. The audience for your private post includes everyone you designated and everyone with a subpoena. 81. What you do outside of work on your own time is your business. Your employer controls your professional hours and your professional conduct. Your personal life, your weekend activities, your off-duty behavior is protected from employment consequences because the separation between work and personal life is a basic principle of the employment relationship. At-will employment is the default rule in 49 states. Montana is the sole exception, requiring cause for termination after a probationary period. At-will employment means an employer can legally terminate you for reasons entirely unrelated to job performance, including lawful off-duty conduct, as long as the stated reason is not one explicitly prohibited by law, such as discrimination based on a protected class. Only California, Colorado, New York, and North Dakota have meaningful lifestyle discrimination protections, preventing termination for lawful off-duty behavior. Most states have no such protections. Social media posts on personal accounts have produced documented terminations upheld by courts in multiple cases, including teachers fired for vacation photographs and police officers fired for political content posted outside working hours. The National Labor Relations Act does protect employees who engage in concerted activity, meaning collective discussion about wages and working conditions on personal social media, regardless of state. Your employer does not own your weekend. Your employer can legally fire you for what you did with it in most states. Knowing which exception applies to your specific situation requires a specialist in exactly this narrow area of law. 82. Your child's school records are private. The Family Educational Rights and Privacy Act protects them. Only you and the school have access. FERPA contains a law enforcement exception, allowing schools to disclose student records without parental consent in response to judicial orders or lawfully issued subpoenas. Schools may also alert law enforcement to information in records when school officials determine a health or safety emergency exists without obtaining a subpoena first. The school official exception allows disclosure to contractors, consultants, and vendors with legitimate educational interests in the records, meaning companies providing educational software, learning management platforms, and classroom technology services may access your child's records under this provision. This disclosure category has expanded significantly with the proliferation of educational technology products in American classrooms over the past decade. Directory information, including a student's name, address, phone number, date of birth, and extracurricular activities, can be disclosed by schools to any requesting party unless parents affirmatively opt out in writing. Military recruiters are specifically entitled to access student contact information under federal law unless parents have filed the opt-out form. A Congressional Research Service report from 2012 found that FERPA's primary enforcement mechanism, withholding federal funding from violating schools, has never once been used in the law's 50-year history. The protection exists in the statute. The enforcement mechanism is theoretical. Your child's records are private from everyone the law forgot to include in the exceptions. 83. America has privacy laws protecting your personal data. Companies cannot simply collect, sell, and exploit your information without legal constraints. The regulatory framework stands between you and the unrestricted commercial use of your digital life. The United States has no comprehensive federal consumer privacy law, Data privacy is governed by a collection of sector-specific statutes covering health data under HIPAA, student records under FERPA, children under 13 under COPPA, financial data under the Gramm-Leach-Bliley Act, and credit information under the Fair Credit Reporting Act. Vast categories of personal data, including your browsing history, real-time location data, purchase behavior, and social connections, are covered by none of these federal statutes. The European Union's General Data Protection Regulation, effective since 2018, requires consent for data collection, grants rights to access and delete your data, mandates breach notification, and imposes fines of up to 4% of global annual revenue for violations. No equivalent framework exists at the federal level in the country that built every major platform collecting the data. California's Consumer Privacy Act and its strengthened successor have effectively set a de facto national standard for companies that chose uniform compliance over state-by-state data management. The American Data Privacy and Protection Act passed the House Commerce Committee in 2022 and has not been brought to a Senate floor vote. America invented the platforms. Europe wrote the rules for them. Congress is still in committee. 84 statutes of limitations exist to provide finality. After sufficient time passes, old accusations cannot be raised. The government had its opportunity, and the window closed. Federal murder charges have no statute of limitations. Federal terrorism offenses have no statute of limitations. Federal crimes where the suspect can be identified through DNA evidence have no statute of limitations. Many states similarly impose no time limit for first-degree murder prosecution. Following high-profile institutional abuse cases involving Catholic clergy, USA Gymnastics, and Harvey Weinstein, among others, over 20 states enacted look-back window legislation retroactively eliminating or extending statutes of limitations for childhood sexual abuse civil claims, allowing lawsuits for conduct that occurred decades ago and would previously have been permanently time-barred. Statutes of limitations are tolled, meaning legally paused, during periods when the defendant was outside the jurisdiction, when the crime was concealed through fraud, or when the victim was a minor who had not yet reached the age of majority. These tolling provisions can extend the nominal limitation period by years beyond the number printed in the statute. Federal financial crime statutes of limitations range from 5 years for standard offenses to 10 years for certain financial institution fraud under specific provisions. The legal guarantee that old charges simply expire with time is real for some offenses, fictional for others, and currently being extended retroactively for a third category by state legislatures working through documented institutional failures. 85. American citizenship is permanent. Once you are a citizen, the government cannot remove that status. It is the most durable thing America offers, and it has no expiration condition. Section 349 of the Immigration and Nationality Act specifies expatriating acts that can result in loss of citizenship, including voluntarily taking an oath of allegiance to a foreign state, serving as an officer in a foreign armed force engaged against the United States, and committing treason or attempting to overthrow the government, provided these acts were performed voluntarily and with intent to relinquish citizenship. Renouncing citizenship requires appearing before a consular officer abroad and paying a fee of $2,350, increased from $450 in 2014, making the United States one of the most expensive countries in which to give up citizenship. The Heroes Earnings Assistance and Relief Tax Act of 2008 created an exit tax applicable to high net worth renunciants, meaning the IRS may still pursue tax obligations from people who have formally given up their citizenship. Naturalized citizens face additional denaturalization risk. The government can denaturalize individuals who obtained citizenship through fraud or concealment of material facts. Operation Janus reviewed thousands of naturalization cases and identified individuals with undisclosed deportable records or terrorist affiliations. Birthright citizenship is the most durable version. Naturalized citizenship has conditions that survive the ceremony. The most permanent thing America offers has a detailed exception schedule. 86. At-will employment means your employer can fire you without cause. Everyone understands this basic feature of American employment law. What fewer people understand is that in most states, your employer can also fire you for legal activities you conducted entirely outside of work hours, on your own property, with your own resources, having nothing to do with your job performance. The default employment rule in 49 states permits termination for nearly any reason that does not constitute illegal discrimination based on a protected class or retaliation for a protected activity. Off-duty conduct, including legal recreational activities, political expression, and lifestyle choices, is fair grounds for termination in most American jurisdictions. Only California, Colorado, New York, and North Dakota have meaningful lifestyle discrimination protections, preventing termination for lawful off-duty behavior that the employer finds objectionable. Documented terminations upheld by courts include teachers fired for vacation photographs posted on personal accounts, employees dismissed for political social media activity conducted on personal devices outside working hours, and workers terminated for legal recreational choices that conflicted with employer preferences. The National Labor Relations Act protects concerted activity, meaning collective workplace discussions about wages and conditions, even on personal social media. Everything else in your off-hours life is unprotected in most states. Your employer owns your job. In most of America, what you do after clocking out is also partially their business. 87. Your child's school records are locked down by federal privacy law. The Family Educational Rights and Privacy Act is the protection. Only parents and the school see what is in those records. The law enforcement exception in FERPA permits schools to disclose student records without parental consent in response to judicial orders or lawfully issued subpoenas, and schools may proactively alert law enforcement to record contents when officials determine a health or safety emergency exists before any subpoena arrives. The school official exception permits disclosure to contractors, consultants, and vendors with legitimate educational interests, a category that has expanded substantially as educational technology products have proliferated in American classrooms, meaning the companies providing your child's learning management system, testing platform, and classroom software may access those records under a provision most parents have never read. Directory information, including name, address, phone number, date of birth, and extracurricular activities, can be released to any requesting party unless you filed a written opt-out. Military recruiters are specifically entitled to student contact information under federal law unless the opt-out form was submitted. A Congressional Research Service report found that FERPA's primary enforcement mechanism, withholding federal funding, has never been used in the law's 50-year history. The teeth are theoretical. The exceptions are operational. Both exist in the same statute. 88. America has data privacy laws that protect your personal information from unrestricted commercial collection and exploitation. The regulatory framework is comprehensive and enforced. The United States has no comprehensive federal consumer privacy law. Sector-specific statutes cover health data, student records, children under 13, financial accounts, and credit reporting. Your browsing history, real-time location, purchase behavior, and social graph are covered by none of these federal statutes. The European Union's General Data Protection Regulation, effective since 2018, requires affirmative consent for data collection, grants you rights to access and delete your own data, mandates breach notification, and carries fines reaching 4% of global annual revenue. The country that built every major platform collecting the data you generate daily has no equivalent framework at the federal level. California's Consumer Privacy Act and its strengthened successor represent the strongest state-level protections in the country and have functioned as a de facto national standard for companies choosing uniform compliance over maintaining state-by-state data management systems. The American Data Privacy and Protection Act passed the House Commerce Committee in 2022 and has not received a Senate floor vote. Congress has been considering comprehensive privacy legislation for over a decade, while the platforms it would regulate have become the most valuable companies in the history of organized capital. The rules were written in Brussels. The platforms were built here. 89. Old crimes go away when the statute of limitations expires. The government had its window. The window closed, and the legal system moves forward. Federal murder charges carry no statute of limitations. Federal terrorism offenses carry no statute of limitations. Federal crimes where suspects can be identified through DNA evidence carry no statute of limitations. Over 20 states enacted look-back window legislation following high-profile institutional abuse disclosures. Retroactively eliminating or extending limitation periods for childhood sexual abuse civil claims, and allowing lawsuits for conduct occurring decades before the legislative change, which would have been permanently time-barred under prior law. Statutes of limitations are told during periods when a defendant was outside the jurisdiction, when the crime was actively concealed through fraud, or when the victim was a minor who had not yet reached the age of majority. These tolling provisions can extend the applicable limitation period well beyond the number appearing in the statute itself. Federal financial crime limitation periods range from 5 years for standard offenses to 10 years for certain financial institution fraud under specific statutory provisions. The legal guarantee that time protects you from old accusations applies to some offenses is fictional for others and is currently being retroactively extended for a third category by state legislatures working through documented cases of institutional misconduct that operated under cover of that same guarantee for decades. 90. American citizenship is permanent. The government cannot remove it. It is the most durable status the country confers, and it has no condition attached that could strip it away. Section 349 of the Immigration and Nationality Act lists expatriating acts, including voluntarily swearing allegiance to a foreign state, serving as an officer in a foreign military engaged against the United States, and committing treason, provided these acts were performed voluntarily with intent to relinquish citizenship. Renouncing requires appearing before a consular officer abroad and paying $2,350, making the United States one of the most expensive countries in the world in which to formally give up citizenship. The Heroes Earnings Assistance and Relief Tax Act of 2008 created an exit tax applicable to high net worth individuals who renounce, meaning the IRS retains financial claims on people who have formally ended their relationship with the country. Naturalized citizens face denaturalization risk if citizenship was obtained through fraud or concealment of material facts. Operation Janus reviewed thousands of naturalization cases and identified individuals with undisclosed criminal or terrorist histories. Birthright citizenship is the most permanent version of the status. Naturalized citizenship carries conditions that survive the oath ceremony and can be revisited by the government years afterward. The most permanent thing America offers has a detailed and operational exception schedule. 91. The Supreme Court exists to hear important cases and deliver final rulings that resolve significant legal questions. When you have exhausted every other option, the highest court considers your appeal. The Supreme Court receives approximately 7,000 to 8,000 petitions for certiorari each year and grants review in approximately 60 to 80 of them, less than 1% of all applications. The court has no obligation to explain any denial. A denial carries no precedential value and does not signal agreement with the lower court ruling. It signals only that 4 justices did not vote to grant the procedural threshold for review, after which the lower court decision stands as the final word with no comment attached. The rule of 4, the informal practice requiring at least 4 justices to vote to grant certiorari, means a petition can be turned away even when 4 justices believe the lower court reached the wrong conclusion, provided those 4 votes do not materialize for the grant threshold. Prisoners and unrepresented individuals file a disproportionate share of petitions. The Informa Pauperis docket for those who cannot afford filing fees is substantially larger than the paid docket and has a grant rate approaching statistical invisibility. 7,000 applications arrive each year requesting the highest court perform its highest function. Fewer than 80 are accepted. The rest receive silence. 92. Education is the foundation of American democracy and opportunity. The government provides it. The right to public education is fundamental. San Antonio Independent School District versus Rodriguez, decided in 1973 in a 5-4 ruling, held that education is not a fundamental right under the federal Constitution, rejecting a challenge to Texas's property tax-based school funding system that produced dramatic per-pupil spending disparities between wealthy and poor districts. No provision of the United States Constitution establishes education as a fundamental right or requires the federal government to provide it. Every state constitution contains some provision guaranteeing access to public education, but the standards range from thorough and efficient in Ohio to adequate in multiple states to uniform in Washington, producing different judicial interpretations of what each provision legally requires in practice. Abbott versus Burke, a New Jersey education funding case, has produced 21 separate court decisions since 1985 and remains active litigation, demonstrating that even with a state constitutional guarantee, defining what adequate education requires is a decades-long judicial project with no terminal endpoint in sight. Common Core state standards are voluntary state adoptions without federal legal force, meaning what is taught in American schools has no consistent national floor. America built its national mythology around the schoolhouse. The federal Constitution has no opinion on whether the schoolhouse must exist. 93. Your passport is your property, and the right to international travel is fundamental. The government cannot simply revoke your ability to leave the country. The Fixing America's Surface Transportation Act of 2015 included a provision authorizing the State Department to revoke, deny, or restrict passports for individuals who owe more than $51,000 in seriously delinquent federal tax debt. As of 2023, the threshold has been adjusted, and over 1 million taxpayers have received certification letters from the IRS triggering potential passport action under this provision. Unpaid child support above $2,500 is grounds for passport denial or revocation under the Passport Denial Program, administered jointly by the State Department and the Department of Health and Human Services. The Terrorist Screening Center can place individuals on the no-fly list without notification, without charges, and with extremely limited procedural recourse. The process for challenging these designations has been litigated extensively with results that vary across circuits. Haig versus AG in 1981 upheld the Secretary of State's power to revoke the passport of a former intelligence officer who was publicly disclosing classified information, establishing that passport rights can be restricted on national security and foreign policy grounds. You owe the IRS $52,000, and your ability to board an international flight is paused. You owe child support, and the same result follows. The right to travel internationally is real and subject to enough statutory triggers that a meaningful number of Americans have already lost it. 94. Net neutrality means your internet provider treats all traffic equally. The principle is established law. ISPs cannot throttle, block, or prioritize content based on source or type. The FCC established net neutrality rules in 2015 under the Open Internet Order, classifying broadband as a Title II telecommunications service. The rules were repealed in 2017 under the Restoring Internet Freedom Order. The FCC voted to restore net neutrality in April 2024. A federal court blocked that restoration in August 2024. The legal status of whether your internet provider can manage your traffic has changed at least 4 times in 10 years, depending on which administration controlled the FCC and which court ruled most recently on the question. Verizon was documented throttling Netflix traffic in 2014 during net neutrality negotiations. AT&T exempted its own streaming service from customer data caps while counting competing streaming services against those caps. Without active net neutrality rules, these practices are not categorically prohibited. ISPs are also subject to national security letter requirements under the Patriot Act, allowing the FBI to compel customer records without a court order and prohibit the ISP from disclosing the request's existence. The pipe connecting you to the internet knows everything you do with it. The law governing what it can do with that knowledge is currently being decided by courts that have not yet finished deciding. 95. An emoji is a casual digital expression. It carries no legal weight. A cartoon face in a text message is not evidence of anything a court would take seriously. Federal prosecutors have introduced emoji in text messages as evidence of intent in criminal cases, including drug transactions arranged through emoji combinations that law enforcement witnesses testified represented specific illegal arrangements. A 2024 Canadian ruling found that a thumbs-up emoji sent in response to a contract constituted acceptance of its terms, a decision immediately analyzed by American contract law professors, examining whether parallel outcomes were possible under United States contract principles. Sexual harassment lawsuits have introduced emoji strings as evidence of workplace hostility, with courts applying a reasonable person standard to determine whether the combination constituted harassment under applicable law. The legal interpretation of emoji is complicated by the technical reality that the same character renders differently across platforms. A particular expression on an Apple device has a measurably different appearance on a Samsung device, meaning the sender's intended communication and the recipient's actual received communication may diverge in ways that no party anticipated, and that courts have not yet systematically addressed in evidentiary doctrine. The thumbs up is potentially binding contract acceptance. The specific cartoon you chose is potentially evidence of intent. Courts are currently building a body of case law around digital facial expressions. The process is ongoing, and your emoji history is already a record. 96. You bought a drone. The sky is open space. Flying your drone wherever you want is a straightforward exercise of ownership over a device you purchased. The FAA Reauthorization Act of 2018 established that the FAA has exclusive authority over airspace management, including low-altitude drone operations, and federal courts have preempted state and local laws attempting to regulate drones in airspace as inconsistent with this federal authority. Drones weighing more than 0.55 pounds, which is 250 grams, must be registered with the FAA for $5. Recreational operators must pass an online safety test. Commercial operators must pass the FAA Part 107. Remote Pilot Knowledge Test. Requirements applying to a substantial percentage of consumer drones sold through retail channels. The FAA's controlled airspace around major airports extends for miles in all directions, covering dense urban areas where millions of Americans live, meaning flying in the backyard of a home near an airport without authorization is a federal airspace violation. A man was sentenced to 30 days in prison in 2015 for flying a drone near the United States Open golf tournament in violation of a temporary flight restriction. Drones interfering with aerial firefighting operations have produced criminal charges under federal statute. You bought the drone. The FAA owns the space it operates in. The interesting places to fly it were already claimed. 97. The laws of the United States reflect the will of the American people. Democracy produces legislation that corresponds to majority preferences. If something is law, Americans chose it through their elected representatives. A 2014 Princeton study by Martin Gilens and Benjamin Page analyzed over 1,700 policy issues and found that when the preferences of economic elites conflicted with the preferences of average citizens, elite preferences prevailed the substantial majority of the time. The study characterized the resulting system as closer to economic elite domination than majoritarian democracy. Polling has shown consistent majority support for universal background checks for gun purchases above 80%, for Medicare drug price negotiation above 70%, and for marijuana legalization above 68%, each of which either failed legislatively or required decades of majority support before partial implementation. Citizens United versus FEC in 2010 struck down limits on independent political expenditures by corporations and other organizations, ruling that such spending constitutes protected First Amendment speech, after which total outside spending in federal elections increased substantially, with a significant portion coming from undisclosed sources. Rucho versus Common Cause in 2019 held that federal courts cannot adjudicate partisan gerrymandering claims, leaving legislative district line drawing to the state legislatures whose electoral survival those lines determine. The laws reflect the will of the people in the same sense that the menu reflects the preferences of the restaurant. Someone decided what was available. Your input was noted. The peer-reviewed academic literature on whose input determined the outcome is available if you want to read it. 98. Your internet provider just delivers your connection. They are not watching what you do with it. What you access, when you access it, and how long you spend there is your private business that passes through their infrastructure without observation or record. ISPs are subject to national security letter requirements, allowing the FBI to compel customer records and usage data without a court order and prohibit the provider from disclosing the request to you, to the press, or to anyone else. Without active net neutrality protections, which as of mid-2025 remain blocked by federal court order, ISPs are not categorically prohibited from logging traffic behavior, throttling specific content categories, or selling aggregated browsing data to third parties under their privacy policies. In 2017, Congress voted to repeal FCC privacy rules that had prohibited ISPs from selling customer browsing histories without explicit consent, returning to a framework where ISP data practices are governed primarily by the provider's own privacy policies rather than federal regulatory requirements. Section 22 of the Communications Act requires ISPs to protect customer proprietary network information, but the FCC's authority to enforce this against broadband providers has been contested as part of the ongoing Title II classification dispute. The pipe knows what you are doing. The legal framework governing what it may do with that knowledge is being actively contested in courts that have not yet resolved it. What travels through the pipe is logged. What happens to the log depends on this week's regulatory status. 99. Marijuana is either federally legal or federally illegal, and the situation, whatever it is clearly defined and consistently applied. Schedule 1 classification under the Controlled Substances Act has placed marijuana alongside heroin since 1970, with no accepted medical use designation. 24 states have legalized recreational marijuana. This creates a documented operational reality, where a state-licensed dispensary conducts legal sales under state law, deposits revenue into a bank operating under federal law that prohibits fully servicing cannabis businesses, employs workers who could lose federal employment if their employer contracts with a federal agency, and sells a product that the DEA simultaneously classifies as having no accepted medical use, while the FDA fast-tracks related compounds under breakthrough therapy designation. The DEA began rescheduling review in 2024, proposing to move marijuana to Schedule 3, which would ease but not eliminate federal restrictions. As of mid-2025, that process remains incomplete and subject to legal challenge. Expungement of prior marijuana convictions has proceeded at state legislative speed in states that legalized, meaning people with convictions for conduct that is now legal in those states are still waiting for record-clearing processes that were announced years ago. You can buy it legally, bank the revenue with difficulty, employ people who might lose federal clearance, and the federal classification review is still pending. The law contains multitudes. They are all simultaneously in effect. 100. The right to vote is in the Constitution and functions as a consistent, accessible, uniformly administered democratic exercise across all 50 states. 35 states have voter identification laws as of 2024, with acceptable ID types varying enough that a student ID valid in one state is specifically excluded in another. North Dakota has no voter registration requirement. Oregon, Washington, and Colorado have automatic registration. Most states require active registration, with deadlines ranging from 7 to 30 days before elections, meaning the same preparation timeline qualifies you in one state and disqualifies you in the next. Maine and Vermont allow imprisoned felons to vote. Several southern states require individual clemency applications to restore voting rights after felony convictions. Approximately 5.2 million Americans were disenfranchised by felony conviction status as of 2022, according to the Sentencing Project, roughly half of them not currently incarcerated. The Help America Vote Act of 2002 attempted standardization following the 2000 election and left substantial implementation discretion to individual states. Partisan gerrymandering of legislative districts has been declared a political question outside federal judicial review under Rucho versus Common Cause. The most fundamental act of American democracy is administered through 50 separate rulebooks that are not required to be compatible, not required to produce similar access outcomes, and not subject to federal judicial oversight for their partisan design. The right is in the Constitution. The administration is in the states. These produce different results. 101. The laws of America reflect democratic choices made by an informed citizenry through elected representatives who are accountable to the people they govern. Every law in this video exists because someone put it there, and most of them remain because no one with sufficient power found removing them worth the effort. The giraffe ordinance in Atlanta costs more to repeal than to ignore. The fried chicken fork law in Gainesville is a tourist attraction. The tipped minimum wage has been $2.13 since the first Bush administration, and survives, because the industry that benefits from it has more sustained lobbying capacity than the workers who receive it. Civil asset forfeiture generates revenue for the departments that practice it. Plea bargaining at 97% produces convictions without the expense of trials. Solitary confinement continues while the United Nations document prohibiting it sits in the same filing system as the policy authorizing it. Emojis are evidence. Your email law was written before the internet existed. The sky above your drone was allocated before you bought it. Your digital purchases were never purchases. 101 laws, loopholes, and legal landmines. One of them is something you repeated as fact to someone who trusted you this year. Drop it in the comments. The more confident you were, the better. If you want to see more, click the video on screen now.